Pretty good. Old matter or fresh matter? Fresh matter. Very good. Let us. It will come. It will come. Yes. It will come. Not tomorrow. It will come. Yes. Kodi. Yes. Wednesday. Wednesday. Fresh matter. Kodi.
My last petitioner is working as a teacher price. Now, last occasion, my last as for next posted for the consideration of interim prayer, but it was.
Kodi.
First was issued to the respondent on 28. I have moved the memo almost 4 occasions.
Give it. tomorrow. Check my.
Last occasion, there have been variation, but today there's a date given back. And not been listed today.
Not been listed.
Not listed.
Give the number.
Tomorrow.
Give the number. Give the. Check my. Yes. You follow it up with the court officer.
10 minutes, this one, page number 1, 1 to 6. Page number 2, 7 to 50.
Yes. No. This I've heard it. No, I'm rejecting adjournment. Yes. That's a different. You may. No, they let. No. You inform the BBMP to make arrangement for the fresh advocate to be present today. Otherwise, I will record whatever you say and proceed. No adjournment in this. No adjournment in this matter. You mentioned that when the matter is called, I'm rejecting adjournment because on how many times?
4 times already once you started representation.
So that this BBMP cannot do like this. They cannot have multiple. They cannot act like this. I am not going to permit them to keep on changing counsels. No, I'm rejecting that. No, I'm rejecting the adjournment. Yes. Next.
Page number 3, page number 16 to 22. Page number 4, 23 to 28. Page number 5, 29 to 32. Page number 6, 33 and 34.
30.
Close, madam. Right.
You appear for.
Regularization matter, my lord. It is getting urgent for the 6th time. You have to take one stand, my lord, because other persons have been regularized. And these are the persons who retained before.
You only submit. We'll see. You only submit. We'll see. Yes. Adjournment rejected. Get ready with the file. Come. Yes.
Page number 7, 37 to 39.
Lord, serial number 36. I appear for the respond number 3, my lords.
Yes.
Lords, the statement of objections are ready, my lords. I will file tomorrow, by tomorrow, my lords. I request for a short accommodation. Lords, any date in the next week, my lords.
In this matter, third time, development is taking.
My lords, only last occasion, my lords.
Yes, we'll file an objection.
My lords, to file statement of objection. One
That's
accommodation.
already filed objection. Only my right friend has not filed objection. But
Lords, by tomorrow, I will file it.
the petitioner lords is before this honorable court challenging the appointment of the third respondent, who is not qualified lords, and the petitioner lords, it is a 10-year post. The tenure is a 4 year. Already he has completed 2 years in the post, though he is ineligible.
Witness.
So, chairman in the.
Let us see. His filing is objection. We'll have it on.
In that case, lords, I request lords to kindly fix for date and 230 any day, lords. Because he has already, it is a 10-year post, lords. Already 2 years he has completed in the
This
post.
the matter in preliminary hearing list on Wednesday. Preliminary hearing.
Please.
Page number 8, serial number 40 to 43.
Serial number 43. I was responded in matter. I gave some accommodation in the I requested time to find some enough for the extension. So I thought
Close.
they take some start accommodation. I will find that.
Who appears for the petitioner? We'll have it next week. At request made on behalf of the R1 to R2, relist the matter on 29.
Number 9, serial number 44 to 49.
40? Yes. Have you informed the other side? You have to inform and then only move.
Number 10,
50 to 54. Page number 11, 55 to 60. Page number 12, 61 to 65. Page number 13, 66 to 70. Number 14, 21 to 23.
Good. Fresh matter, old matter. Good. Not tomorrow, but we'll give a date. Take the date.
Hello.
This is number 1. Give me 1 second.
So
Serial
now
number.
only the provisional list is announced, isn't it? Let us see. Take out.
I appear for the petitioner, my lord, in this matter.
Which matter?
Serial number 1, my lord.
Which court, madam?
Court 11, ma'am, my lord.
Which are writ petition number?
Writ petition number is, my lord, 13721 of 22, my lord.
No, there's some mistake. Just please check, recheck.
Sorry, my
The
lord.
issue AGF accepts the HCGP accepts notice for respondent 1, 2, 3 thrice thrice. Naga has right to accept notice for the 4th respondent. Yes.
Date can be right out of the promotion being given, the board is likely to meet for effective promotion based on the provision. Date in the party, they can be.
This is the matter in the week commencing from 10th of October. Yes.
Number 2.
ನಿನ್ನೆ ಇದಾಗಿತ್ತು ಇಷ್ಟ ಆಗಿತ್ತು ಗೌರ್ಮೆಂಟ್ಗೆ ಡೈರೆಕ್ಷನ್ ಮಾಡೋದು
So that inquiry is pending. Huh? So inquiry is pending. Then you accept. But inquiry is pending, isn't it? AGA accepts notice for respondents 1, 2. One to 6. Emergent notice to respondents 7 and 8. Objections, if any, to be filed within 2 weeks. This is the matter after 2 weeks.
previously direct respond corporation the case of the transfer guideline. However, the respond corporation now issued the endorsement in 114 without considering the fact that also in view of the fact that the handicap, if it is in view of the transfer guidelines, you want to have been included in the present place. However, the endorsement that connection in page 114 is not the state the provision regard to the transfer guideline. The only state that the present posting is within 2 kilometers distance the asset should not be put in.
May I make a submission?
In the month of March. That way only 6 months service.
May be permitted to make a submission, my lord.
Yes, yes,
I have
Yes.
been instructed to take notice on behalf of respondents 1 to 3 here in this, my lord.
yes,
Pursuant to your lordship's order, the representation was given by the petitioner and it has been considered, and there is an order which is placed at annexure N at 114, your honor.
yes,
Pursuant to this, I would like to take further instructions, what is the office note and other things, and place it before your lordship, because it is the representation is been considered is what has
Yes.
been instructed to me, your honor, and a detailed order has been passed in consonance to 9B of the regulation. Let me secure the original file from the office, and what is the
Yes.
office note put up and all, I'll verify and make my submission clear, make the submission in clear manner, my lord.
just find out if
Yes,
the
my lord.
the procedure is followed. Otherwise,
my
you
lord.
have to ask them to redo it. That's all. You don't even have to wait till the next day. Look into the procedure. If procedure is followed, you place it before the court. Otherwise,
my
you advise appropriately.
My
When
lord,
do you want-
as per my instructions telephonically, what was given to me, the procedure as contemplated has been followed, and a speaking order has been passed is what has been instructed to me over telephonically. Before
Let us
making
see.
any further submission, let me secure the file and place it before your lordship, your honor.
When do you want it?
Maybe this week, maybe immediately commencing week, madam, my lord.
Relist the matter in preliminary hearing list on next Thursday. Yes.
I might be permitted to take notice, my lord.
Learned Counsel H. Chandrachud is permitted to accept notice for respondents
1 to 3, your lordship.
1 to 3. Yes.
Filling up the backlog vacancy. Court has passed an order. And finally, the government has done for other departments, but not in Interim. They have left it to that the only consideration.
Yes, you look into it. Learned HCGP accepts notice for respondents 1 to 3. They only want a direction that you fill up backlog vacancy as per the special recruitment rule. So we'll have it in preliminary hearing week after next. You find out and then make submission. List the matter in preliminary hearing list on 29.
There is a request for a direction to continue the service of the Vision, that as a laboratory technician in a particular project, that there is a previous request which your lordship disposed of, granting the benefit under the maternity benefit act. Insofar as the issue relating to continuation of the petitioner is concerned, the lordship reserves liberty to for adjudication in separate case. Therefore, my lord, I have filed this request. Kindly see, my lord, next year Q.
Where is the observation? The previous.
My lord, page 59, your lordship. Page 59. Last term.
Yes.
So far as the other rights of the petitioner regarding continuance of thereafter till the completion of the project period is concerned, the said aspect requires determination by applicable law, not linked with the benefits flowing from the maternity benefit. And accordingly, the court is of the opinion that the said aspect, though being a related cause of action, requires a separate and independent consideration.
Now continuance in the same
force, as laboratory technician, which you are working earlier before applying for maternity leave.
Then you take out notice.
Please.
Now you are not in employment. They've refused to take you.
Yes.
They're saying
They
it's
refused to take me back.
saying
They
that it's
refused
a
to
term appointment.
On 6/7/2021, the petitioner gave birth to a child. Very next day, she has been relieved. That is on 7/7/2021. Thereafter, she reported to duty on 3/1/2022, saying that my maternity leave period is over. And please take me back to the duty as laboratory technician and also give me the maternity block. Both are refused. Thereafter, my lord, I upload this on the court, this particular requisition. Your lordship heard it in detail, then your lordship directed them to grant maternity benefit. Of course, it is so far it is not granted, separate aspect. Well, as far as the right of the petitioner for continuance in that particular project till the completion of the project in the year 2025-26 is concerned, your lordship gave liberty to file a fresh. So therefore, my lord, I am before you.
Who appeared for the respondents?
For second response. First response.
The counsel Shri Chandrakant Gowle is directed to accept notice for the second respondent. AGA accepts notice for the first respondent. Release the matter and preliminary hearing list on 29.
Act of transfer, and they are subjected to suspension. Was challenged before them. Later on, he was revoking the suspension, he has been given posting in Sorba. That has been challenged before this Honorable, considering the point that my wife is also a government servant. The criminal case which is initiated has already been stayed. This Honorable Court, as per order dated. Sure. C has observed that since the persons who have been facing the similar allegation, they have been accommodated in Bangalore itself. The petitioner cannot be kept out since his wife is also working there. The Lordship has directed to give a representation and further directed the authorities to consider and pass a detailed order. Accordingly, as per Annexure D, I have given a representation. A detailed order has been passed as per Annexure E, recalling the order of my posting to Surpa and given me in a non-executive post in Bangalore. That order is dated 25/8/2022. Accordingly, I reported on 26/8/2022. While I was working, and another order is passed by the government, to say the KPTC, posting another person to my place. That has brought to the notice of the chief engineer, because since my posting is virtue of a detailed order passed by the authority, and there is only one post existed in the place, he cannot be accommodated replacing him. Till September 6th, no action has been taken. Now the authority is saying that no, you have to make a. Within a span of 5 days.
Where is that fresh order?
Fresh order is
Cancelling the earlier order.
No, in the fresh order, there is no such order as notifying that I am working over there. They show that it is a vacant post.
This should be.
Annexure A, Lordship kindly take for a moment. Page 13. Serial number 1, Anandappa. Call number 2, 220 kV ವಿದ್ಯುತ್ ಸ್ಥಿರೀಕರಣ ಕೇಂದ್ರ ಅಂತರಸನಹಳ್ಳಿ ತುಮಕೂರು ತಾಂತ್ರಿಕ ಶಾಖೆ ಟಿಎಲ್ ಮತ್ತು ಎಸ್ಎಲ್ ವಿಭಾಗ ಕೈಪ್ರೀಣಿಯ ಬೆಂಗಳೂರು.
That is where you are working.
That is where I am working. Your Lordship kindly get it in Annexure E, page 29. Your Lordship get it. Page 29. Annexure E, page 28. A detailed order is passed in since the direction is issued by the Honorable Court. I request your Lordship kindly take for a moment page 29, the operative portion.
Yes.
Second paragraph. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ದಿನಾಂಕ 15/6/2022 ಆದೇಶದಂತೆ ಸದರಿ ಅಧಿಕಾರಿಯು ದಿನಾಂಕ 28/6/2022 ಮನವಿಯನ್ನು ಪರಿಶೀಲಿಸಿ ಸದರಿ ಇವರನ್ನು ಕಾರ್ಯ ಮತ್ತು ಪಾಲನಾ ಉಪವಿಭಾಗ ಮೆಸ್ಕಾಂ ಹೊರಬಯಲಿಗೆ ಕೈನಾತಿಸಿರುವ ದಿನಾಂಕ 16/5/2022 ಆದೇಶವನ್ನು ಮಾರ್ಪಡಿಸಿ ಸದರಿಯವರನ್ನು ಟಿಎಲ್ ಮತ್ತು ಎಸ್ಎಸ್ ವಿಭಾಗ ಕೆಪಿಟಿಸಿಎಲ್ ಪೀಣ್ಯ ಬೆಂಗಳೂರು ಇಲ್ಲಿ ಖಾಲಿ ಇರುವ ಸಹಾಯಕ ಕಾರ್ಯನಿರ್ವಾಹಕ ಹುದ್ದೆಗೆ ಸ್ಥಳ ನಿಯುಕ್ತಿಗೊಳಿಸಿ ಸದರಿಯನ್ನು ಸ್ಥಳ ನಿಯುಕ್ತಿಗೊಳಿಸುವ ಸ್ಥಳದಲ್ಲಿ ಆದೇಶವನ್ನು ಪಡೆದು ಕೂಡಲೇ ಕಾರ್ಯವರ್ತಿ ಮಾಡಿಕೊಳ್ಳತಕ್ಕದ್ದು. ಅಲ್ಲಿಯವರೆಗೂ ಸದರಿಯವರು ಅಮಾನತಿನಲ್ಲಿ ನಿರ್ವಹಿಸಲಾಗಿದೆ ಎಂದು ಪರಿಗಣಿಸಿ. Accordingly, Annexure F I reported on 26.
You reported.
I reported. Page 26, Annexure F.
This page
26. Sorry, 31. 31. Page 31.
you have reported.
I am reported on 26/8/2022, and that has been fortified by a direction of the chief engineer. Annexure H, your Lordship kindly take for a moment, page 39. Because after the order of another person posting over there, the chief engineer, the superintendent engineer writes a letter to the chief engineer. He cannot be accommodated since for the post is already filled up. Nevertheless, now they say that I have to make it.
Petitioner. Normally, I don't give ex parte, but
Otherwise, I have to file a contempt for the reason that since they have passed another order, I have before this only.
petitioner was posted at the office of the technical department, TL and SS division, KPTCL Pina, as per the order at Annexure
Connection E, I have been posted. In pursuance to order of the sample.
as per the order at Annexure E dated 25th August 2022. And the said order also refers to the earlier order of this court passed in WP number
10104 of 2022.
10104 of 2022. He submitted that as per the order at Annexure E, petitioner has reported for duty as is evidenced from the proceedings at Annexure F dated 26/8/2022. Subsequent thereto, on 29th August 2022, an order is passed posting respondent number 3 in the petitioner's place while showing petitioner's post to be vacant. Prima facie, the order at Annexure A is legally misconceived insofar as the petitioner's posting and assumption of charge at the office at Pina as a result of keeping that post occupied. If that were to be so, posting of the third respondent in the petitioner's place without any transfer order of the petitioner would not arise. Even otherwise, there is no order transferring the petitioner from the post at Pina, and the question of posting anybody in his place would not arise.
There is only one post of assistant executive engineer.
Subject to further consideration, there would be stay of the order at Annexure A. Counsel Shri A. Chandrachud is directed to accept notice for respondent 1 and 2. It's a matter week after next. They cannot, now this, we have also held in one case that you cannot pass an order of transfer unless there is a vacancy.
Unless notifying the post for the transferring. That is the law laid down by this. In this case, SEMA has been further interpreted by the division bench.
And it's not open.
It's not open.
So what is the solution to the problem? No, but that you show it to the government. That I don't show it to me. Put it.
Already placed before this on.
Yes. You're reading at page? Yes. 19 at sub number 7, is it? Yes. Page. Yes. All other gazetted technical now these staff nurses are C and D. Yes. For group C and D, ministerial staff, non-technical staff. The method of the selection of C and D ministerial posts shall be as per the provisions of Karnataka Civil Service Code. And in the Karnataka Civil Service D posts by the competitive examination and selection in the elder group. Subject to the modification of the selection specified in these codes and perform in now we can see what is the last occasion argued that the BHI has power not to appoint the good say lead post. What we have power is only not to appoint on that basis for a period of 6 months. It has to not to 43. Procedure 14. Now then, how did these other 200 people, how were they appointed? First time. No, first time 200 people. That time these people didn't apply. Page. Yes. So where is that recommendation? Let us have.
There is para 10 is also relevant.
I'll come. Let us see. You have that recommendation.
That I don't have.
Well, when your officers come, must they not come with the file? Why do we invite them? No, why? But we are not inviting them to waste their time or to waste the court's time. I've taken this matter umpteen number of times. People are waiting in the queue because their matters are not reaching. Now then why do officers have to come?
It is the internal records between them, my lord.
Let us see. Now you have the order of the court of 23/1/2019. Let us see what that order. Let them get that recommendation by WhatsApp. Let them call the concern to send it. Possible. 1 o'clock. Yes.
This is after. Unfortunately, this petition went to petition bench, and again it was before this bench. And the matter, similar matter, this court has granted interim order not to relieve the petitioner's as. Similar order may be granted to the petitioner. Judge was pleased to pass order. Same order I have submitted.
Light of the interim order. First in identical factual matrix, including in WP 1945 of 2022. Petitioner not to be relieved from service till the next date. This is the matter along with WP 11945 of 2022. The first title is at page.
Starts with 25. 88 petitions.
What is this? So many numbers. No, what are you? Can we give an interim order? Till when is this? Till when is?
Lordship, actually, even before the division bench, this order has been continued. There was an order by this honorable court, not only granting to recruit them, there was an order, which is state the second part. As part of the first part, still.
No, have you been terminated now?
Huh?
Have you been terminated?
No, not terminated.
Let us see. Let them take instruction. Let us see. On the next date, I'll pass it on. No.
Similar order maybe.
Let us see. Let us see.
Lordship may
Let us see. Now, on parity, if in the connected matters there's an interim order, till the matter is decided, we may have to pass the same order. Just get preliminary instruction. I'll have it in the same stage on Wednesday, and we'll pass an order on parity. Till the matter is decided, they are entitled for same. Only because there's some 80 people, anyhow you take a instrument.
What has happened is only my matter came first.
Let us see.
It was sent to division bench.
GP accepts notice for the respondents 1 to 6. Karnataka Examination Authority. Okay, NK Ramesh. NK Ramesh is directed to accept notice for the 7th respondent. This is stopgap lecture.
It's a stopgap.
The stopgap lecture. No, stopgap lecturers. Stopgap lecturers. Appointment is till when? How? Correct, but now since these matters are being heard, now if the academic year, according to what your submission made yesterday, ends till on 30th of September, then you wait till the matter is decided, till you call afresh. Otherwise, now you call afresh. Then no, we'll. So correct. So why don't you work out some counseling process? Now suppose now according to you there are no students, you want to reduce it. We will not come in the way of that. There can be an order from the court itself, and you have a counseling process. Now since it has come to the end, now you have to call fresh. Instead of calling a fresh, if these people who are already working and there is a need in those places, some of them are working for many years, you continue them. If how you can do that? Correct. If they work for more than 5 years at least. No, all these people,
Lordship, in this
no,
case.
all these people
petitioners have
are,
passed all the exams. This is what my contention is also. They have passed all the exams. And your Lordship may kindly see the first petitioner is age 54. He's worked from more than a decade. And
No,
what
then-
has happened is there are several.
now you take instructions. I'll have it on Wednesday.
Lordship, some of the prayers of my prayers have become infectious now because of the time frame when before they were to be recruited. Now I have only two options to seek parity grounds on the as per the judgment passed by has become infectious now. Your Lord. Now only my prayer in he will survive. The prayer is I'm seeking parity grounds because these petitioners.
No, you are not working or you're working.
You're working, my interim prayer is also not to discontinue their services. My interim prayer is only not to discontinue their services. If I am not continuing, I would not have sought for.
You find out. Get instructions. I'll have it.
Lordship, these petitioners are
Let us
I'm doing service
No,
oriented.
let us see. Let
There be an interim order.
no.
No, at least for the petitioners who are, in fact, the
Let
government.
us see. What is the hurry? Now they have not been terminated. I'll consider it on the next stage. You give whatever information you have to them. Let them verify. Those who are in service, you make a separate list. Those who have been discontinued, make a separate list. Those who have taken part in the recruitment process, you make a mention. If you have not taken part in the recruitment last time, then there's a difficulty. That you give information to them.
Because some can't enter the recruitment process itself because their age limit has crossed because they were.
That you make a list and give it to them. Let us see.
That observation may be made. Those who are not relieved,
But-
let them, their services not be relieved. Only
That you make a list and give out of 88%, you make a separate list of how many of them took part in the recruitment process, how many of them are working, and then give it to them. Let them get instruction. You look into it dispassionately. If there are some deserving people, you make a mention.
when you appeal, your Lordship, the appeal order may be considered. The appeal order, there is an interim order to not to relieve. That is appeal in writ appeal is also pending.
That is a consideration of
Your Lordship may kindly see
That's the matter. On next Wednesday. Next Wednesday we'll share. I'll pass. You give whatever information they want. You give it to them. Now I've asked them to give information. Let you give whatever information they want. Then you look into it and make some.
I mentioned about the colleges, the way yellow petition last week colleges.
Let us see.
College, they are working, everything is being given.
Now you give what?
Can't make suspicions like that without even.
Let us see next Wednesday. Yes. Mistake. No? No orders. No further orders. Let us see. Make submission next date after getting instruction. Next order. Correct. Just one, Nagashri, 80 people, 100 people, they come and file. What we can do? So if we have to give interim order, straight away 88 people will come in. That you verify, one. Two, in that other matter also, that some yesterday you were saying, that before you call for the fresh, after the academic year, you design of some plan, wherein those who are deserving according to you, meet the criteria. You have some counseling. So those who fulfill the criteria, there's a requirement, and it can be a seniority come merit based, whatever, that you take your call. So you would design a system wherein old people will be given weightage, and that you may restrict to, you say, 50% of the posts with weightage, and the other 50% for some new entrants. You make out some plan like that, rather than just passing, then again they come back to the same. You look at it how it must be done. Till then, you go slow on bringing fresh people, then you'll have two people till this is solved. At least till some order is passed on this, you defer it. You ask your consult, you defer it till some order is passed. In the next 1 year, hopefully, at least in the next 1 year, the matter will be decided. Defer it till then. Let us see. Correct, but till some order is passed on whether these people have right or not, you may have to defer it. Correct. So by the next 10 months, hopefully, you pass a resolution to defer it with the observation that some order we will try and get a decision either way on this. Think about it, because now again, if you are going to have thousands of people going to come, there's going to be correct. So at least till it's decided, you defer it. You look get instructions and looking to ask your client officers to look into each of the cases, so that I've given. So some of them, if genuinely you can consider, you consider. Then we'll see what. And also you come out with some plan on the fresh notification. Think about it. And yes. No, correct. I will adjourn if it requires adjournment. Now, who is going to appear in this matter? There's a Tuesday. Thursday. Tuesday. Thursday. This is the matter in the same stage on Thursday. Now the problem is we are relisting. So other lawyers are shouting. They're saying only matters which are being listed are being relisted. Yes. In the same stage. Yes. What is this matter?
Petitioner's retirement benefits were not disbursed. The respondent already passed an order. Part compliance of that, they've already disbursed 3.5.
Where is that order?
Next year. See.
In the next year?
Last operative part.
Yes.
ಮೇಲ್ಕಂಡ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿದಂತೆ ಎಲ್ಲಾ ಅಂಶಗಳನ್ನು ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಶ್ರೀ ಪಿ ಚಂದ್ರ ವಯೋನಿವೃತ್ತಿ ಇವರಿಗೆ ಸಲ್ಲಬೇಕಾದ ಅಧಿಕಾರಿ ಸೌಲಭ್ಯಗಳನ್ನು gratuity, they have calculated the amount. At the end, it says, ಒಟ್ಟು ಸೇರಿ ಪಾವತಿ 7,55,398ಗಳನ್ನು ಪಾವತಿಸಿ.
This is to be paid by whom?
Respondent number 3.
Respondent? Yes. Now they paid some portion of it.
They have, your lordship, they kindly see annexure D. They have actually released 3,50,000. All that I am seeking for is the remaining.
There is no inquiry, nothing pending. Yes. Now, retirement benefits. So now, correct. Now you have to pay balance amount. That's all.
But that was with respect to the retirement benefits not being disbursed.
No, okay, now let us ignore that. Now they want the retirement benefit. No, that's there. Why you are not paying the amount? Why have you withheld it? No, what is it? No, there's no dispute. What is the dispute? Yes. Yes.
They have actually cut off a little amount from my entire benefits that I was entitled.
No, then you get instructions and you say how much time you require, who are the other employees in seniority, which you have to settle. You can't withhold retirement benefit.
After 2020.
No, now you get instructions. How many employees are above the petitioner in seniority? Now, you find out and you file a you file a memo and you will record and close it. You find out also how many employees are senior to the petitioner who are still waiting for disbursement of. You get all the details. Correct. What I'm saying is you make a schedule. How many people are still waiting in seniority? Let us see that you get instruction and file a memo. You file a memo and record it and close it. You get instructions. How much time they want, what is the amount, etc. And you file a memo. Relist the matter week after next. Let us see. What is this matter? Provisional. At the last chance, objections to be filed by the respondent. This is the matter after 2 weeks. Yes. The same stage. Yes.
Serial number 14, I would like to require
Yes.
small accommodation to file my statement, my lord. I've just received my instructions only today morning. I will request a short accommodation to place it on record, Your Honor.
Notice of notice is awaited in respect of respondent. That's may I request the notice may be directed to be served respondent number.
Okay. I do not notice ಏನಾಗಿದೆ. office to put up a report regarding notice to R5. In the interregnum, notice to be served to R5 to respondent number 1. Is the matter week after next. Eighth stage, yes.
Interim order against.
Interim order earlier. What is the interim order granted?
That's the petition. Right, not to be relieved from.
Transfer or what?
Interim order, my lords, on 18/8.
And then let it, then why in the same stage? Let it come.
Because it may be disposed of, it is covered by my lord's judgment.
Okay, let us. Interim order earlier granted is extended till the next date. Yes.
Petitioner in this case. Petitioner is before this court, challenging the impugned endorsement issued by the second respondent by annexure P. In withdrawing the UGC pay scale granted to the petitioner. The petitioner was appointed as a lecturer by the management by lordship on 18/5/1992.
Withdrawal of
UGC pay scale lordship, which has been extended by the first respondent government pursuant to order annexure E lordship. As per annexure E has been extended to the benefit of UGC pay scale. Thereafter, the same has been withdrawn by issuing an endorsement, which has been challenged before the Honorable Court in the filing a writ petition, my lordship. This Honorable Court has directed the respondent with the impugnant in the withdrawing the UGC pay scale has been without issuing a notice and offering explanation of the petition. Therefore, directed the respondent to treat that notice as a endorsement as a notice, and after affording opportunity, the appropriate order may be passed thereon. Until consideration of the issue, my lordship, the petitioner is entitled to receive the UGC pay scale as per the order of this Honorable. So, in view of the order of this Honorable Court, my lordship, the petitioner is
who is the answering respondent? Who is the contesting respondent?
contesting respondent is the second respondent, my lordship.
That's the
The government,
state itself.
state itself.
Now, where is the considered order that is passed?
Annexure P, my lordship, page 82.
Yes. Para? Read the important paragraph.
Yes, my lordship. From the second paragraph, the writ petitions are allowed. The endorsement dated 6
You're reading at page?
page 83, my lordship.
No, which annexure?
Annexure P,
Annexure P is the endorsement.
endorsement. That is the impugned order.
Yes.
The writ petition are allowed. The endorsement dated 6/12/2013, while annexure L is treated as show cause notice, for which the petitioner permitted to make detailed representation. On such a representation being submitted, the respondents are directed to pass appropriate orders or issue appropriate endorsement. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಅರ್ಜಿದಾರರಾದ ತಾವುಗಳು ದಿನಾಂಕ 17/6/19 ಈ ಕಚೇರಿಗೆ ಮನವಿ ಸಲ್ಲಿಸಿ ಸದರಿ ಮನವಿಯಲ್ಲಿ ತಮ್ಮನ್ನು ಸರ್ಕಾರದ ದಿನಾಂಕ 18/5/11 ಆದೇಶದಲ್ಲಿ ವೇತನಾನುದಾನಕ್ಕೆ ಒಳಪಡಿಸಿದ್ದು ದಿನಾಂಕ 19/2/97 ಸರ್ಕಾರದ ಸುತ್ತೋಲೆಯಲ್ಲಿ 33/90ರಿಂದ 7/2/94 ಅವಧಿಯಲ್ಲಿ ನೇಮಕಗೊಂಡ ಉಪನ್ಯಾಸಕರುಗಳಿಗೆ ಯುಜಿಸಿ ನಿಗದಿಪಡಿಸಿರುವ ವಿದ್ಯಾರ್ಹತೆಯನ್ನು ಹೊಂದುವಿಕೆಯಿಂದ ವಿನಾಯಿತಿ ಇರುವುದರಿಂದ ಅದರನ್ವಯ ತಮಗೆ ಯುಜಿಸಿ ವೇತನ ಶ್ರೇಣಿಯನ್ನು ವಿಸ್ತರಿಸಿರುವುದಾಗಿಯೂ ಹಾಗೆ ಅದೇ ವೇತನ ಶ್ರೇಣಿಯನ್ನು ನಮಗೆ ಮುಂದುವರಿಸುವುದು ಕೋರಿರುತ್ತೀವಿ. ನಂತರ ಕಚೇರಿಯ ಹಂತದಲ್ಲಿ ನಡೆಸಿದ ವಿಚಾರಣೆಗೆ ತಮ್ಮ ಪರವಾಗಿ ಹಾಜರಿದ್ದ ವಕೀಲರು ದಿನಾಂಕ 25/4/22 ಸಲ್ಲಿಸಿದ ಲಿಖಿತವಾದದಲ್ಲಿ ಮಾನ್ಯ ರಾಜ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟ್ ಅಪೀಲ್ ಸಂಖ್ಯೆ ಸೋನ್ಸೋಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ನೀಡಿರುವ ದಿನಾಂಕ 15/4/21 ತೀರ್ಪಿನನ್ವಯ ಅರ್ಜಿದಾರರಾದ ಡಿ.ಎಚ್. ಪ್ಯಾಟಿ ಹಾಗೂ ಜಯರಾಮ್ ಇವರು ಯುಜಿಸಿ ವೇತನ ಶ್ರೇಣಿಯನ್ನು ಪಡೆಯಲು ಅರ್ಹರಾಗಿರುತ್ತಾರೆ ಎಂಬುದಾಗಿ ತಿಳಿಸಿದ್ದು, ಈ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಿದಾಗಿ ರಿಟ್ ಅಪೀಲ್ ಸಂಖ್ಯೆ ಅರ್ಜಿದಾರರ ಪ್ರಕರಣಕ್ಕೂ ಹಾಗೂ ತಮ್ಮ ಪ್ರಕರಣಕ್ಕೂ ಯಾವುದೇ ಸಾಮ್ಯತೆ ಇರುವುದಿಲ್ಲ. ಅಲ್ಲದೆ ಸರ್ಕಾರದ ದಿನಾಂಕ 19/2/97 ಸುತ್ತೋಲೆಯನ್ನು 33/90ರಿಂದ 7/2/84 ಅವಧಿಯಲ್ಲಿ ನೇಮಕಗೊಂಡ ಉಪನ್ಯಾಸಕರುಗಳಿಗೆ ಯುಜಿಸಿ ನಿಗದಿಪಡಿಸಿರುವ ವಿದ್ಯಾರ್ಹತೆಯಾದ ಎನ್ಇಟಿ ಎಸ್ಎಲ್ಇಟಿ ಹೊಂದುವಿಕೆಯನ್ನು ವಿನಾಯಿತಿ ನೀಡಿರುವುದಿಲ್ಲ. ತಮ್ಮನ್ನು ವೇತನಾನುದಾನಕ್ಕೆ ಒಳಪಡಿಸಿರುವ ಸರ್ಕಾರದ ಆದೇಶ ದಿನಾಂಕ 18/5/11 ಆದೇಶವು ಜಾರಿಯಾಗುವ ಪೂರ್ವದಲ್ಲಿಯೇ ಸರ್ಕಾರದ ಸುತ್ತೋಲೆ 19/2/97 ಸುತ್ತೋಲೆಯನ್ನು ಕೂಡಲೇ ಜಾರಿಗೆ ಬರುವಂತೆ ಸರ್ಕಾರವು ದಿನಾಂಕ 11/1/11 ಪತ್ರ ಸಂಖ್ಯೆ ಸೋನ್ಸಿ ಹಿಂಪಡೆದಿರುವುದರಿಂದ ಹಾಗೂ ತಾವುಗಳು ಯುಜಿಸಿ ನಿಗದಿಪಡಿಸುವ ವಿದ್ಯಾರ್ಹತೆಯನ್ನು ಹೊಂದದೇ ಇರುವುದರಿಂದ ತಮಗೆ ಯುಜಿಸಿ ವೇತನ ಶ್ರೇಣಿಯನ್ನು ಮುಂದುವರೆಸಲು ನಿಯಮಗಳಲ್ಲಿ ಅವಕಾಶವಿರುವುದಿಲ್ಲ ಎಂಬುದಾಗಿ ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ. ಎಂಡೋರ್ಸ್ಮೆಂಟ್ issued by the respondent. Lordship, admittedly, the petitioner was appointed on 18/5/1982 as per Annexure A, my Lordship.
18/5.
18/5/1992. His appointment has been admitted to grant by Annexure B on 18/5/2011. Wherein, prior to that, my Lordship, the government has issued a circular by Annexure C on 19th February 1997, wherein relaxed the prescribed qualification for the lecturers who have been appointed in between 30th March 1992 to 7th February 1994, while Annexure C, page 27, my Lordship, wherein we can find it.
But you were appointed after this.
Before that, my Lordship, with 1992,
Annexure, which is the
Annexure C,
which is circular?
circular Annexure C, my Lordship, are dated 19th February 1997. I have produced the typed copy. Last paragraph of the Annexure, page 27.
Page
27. The typed copy at 29, my Lordship. The matter has been examined in length, and it is hereby clarified that minimum educational qualification of master's degree with at least 55% marks prescribed under government number so and so is not applicable to the candidates who were appointed between 30th March 1990 and 7 to 1994.
That was carried.
So you were appointed on
1992, my Lordship, in between this period. So prescription of UGC regulations and qualifications, my Lordship, is exempted to those who have been appointed in this between this period, my Lordship.
So where is your order of appointment?
Annexure A, my Lordship,
Page
page 18.
Yes.
18/5/1990. In this regard, my Lordship, I am entitled for UGC pay scale. In the meanwhile, my Lordship, the government who have been appointed in this period working in various aided educational institutions have extended the UGC benefits by order dated 11th March 2011 by Annexure D. 62 employees working in different aided educational institutions have been extended, who have been appointed in between 30th March 1992, 7 February 1994.
annexure
Annexure D.
by relying on the same government order.
Yes, ma'am. Relying upon the same government order. Considering all these aspects of Lordship, well, Annexure E, page 40.
Annexure
ಅದರಲ್ಲಿ the first order ನಲ್ಲಿ ಹೇಳ್ತಾರೆ ಸರ್ಕಾರದ ಸುತ್ತೋಲೆ Annexure D ನಲ್ಲಿ ಉಲ್ಲೇಖ ರೆಫರೆನ್ಸ್ ಅಲ್ಲಿ it is mentioned, my Lordship, circular date ದಿನಾಂಕ 19/2/97 ಸಂಖ್ಯೆ so ಸರ್ಕಾರಿ ಸುತ್ತೋಲೆ. Based upon that, my Lordship, 62 employees working in the different aided college, they have been extended to UGC pay scale. When Annexure E, my Lordship, page 40. On 23/8/2012, the government has extended the UGC pay scale to the petitioner by Annexure E. With effect from the date of admitting his appointment to grant in aid, that is on 18th May 2011, by page, my Lordship, 40. Proceed to that order, my Lordship. The Joint Director of Collegiate Education has issued one more order on 27/9/2012, wherein extending the benefit of UGC pay scale. And accordingly, the petitioner has extended the UGC pay scale, he received the same. In the year 2013, my Lordship, on 6/12/2013, they have issued an endorsement withdrawing the UGC pay scale to the petitioner and other employees, wherein which has been challenged before this honorable court as per Annexure H, my Lordship. This honorable court has directed Annexure H. Page relevant order in my Lordship, page 49. The writ petitions are allowed. The endorsement dated 6/12/2013 with Annexure L is treated as show cause notice for which the petitioners are permitted to make detailed representation. On such representation being submitted, the respondents are directed to pass appropriate orders or issue appropriate endorsement within a period of 3 months thereafter. Till reconsideration, what was granted as per Annexure H 23/8/2012. That is the wherein in this petition, my lordship, in instant annexure E, my lordship, wherein the government has
No,
extended the UGC pay scale.
Now, what is their logic now in withdrawing? What is their legal basis now?
My lordship, according to them, my lordship, my appointment was admitted to grant in aid subsequent to withdrawal of the government order. But at nowhere it is stated that only you are entitled to receive the UGC pay scale after admitting your appointment to grant in aid. The consideration of the government, my lordship, the period where from 90 to 94 who have been appointed are only exempted and they are entitled for all benefits as per the UGC regulations.
So you are saying the date of admitting into grant in aid is not a relevant.
Not a relevant point.
Only the date of appointment.
Only the date of appointment as per the annexure C, my lordship, circular.
Annexure C.
C.
Now let us see if it requires some consideration.
My lordship, in identical circumstances, my lordship, this honorable court in writ appeal, my lordship, with annexure N, page 971. And later, principal, my lordship, the 11th page is page 80, parent 12.
Identical, is it?
Identical. In fact, in so far as these lecturers who were appointed between 13/4/1990 and 17/2/1994, a clarification was issued in the government order dated 17/3/2011. Respondent number 1 is also beneficiary of the said clarification in as much as possible.
Yes. What do you say? Annexure? Page? Annexure? Let us see. We'll consider it. You find an objection. It is the petitioner challenge the endorsement at annexure P dated 30th July 2022, whereby it's observed that continuance of UGC pay scale would not arise as the same is impermissible. The petitioner admits that insofar as the employees appointed between 30th March 1990 and 7/2/1994, in terms of the circular of 19 February 1997, enclosed at annexure C, there is an relaxation relating to minimum qualification as regards such of the employees appointed during the aforestated period. Next, it is noticed that the petitioner has been appointed on 18/5/1992. It is also noticed that the division bench in
71.
WA 2852 of 2018 at paragraph
12, my lordship.
Paragraph 12 is observed an identical factual matrix, while stating that the state cannot apply conditions stipulated by UGC retrospectively to those lecturers appointed in the aforesaid period, subject to further consideration. There would be a stay of the order endorsement at annexure P. However, the petitioners are to file indemnity bonds as prescribed. No, now in case you lose, then what happens? Let us see. Needless to state that the interim order is subject to final orders to be passed. Interim order to be enforced till the next date. The respondents are at liberty to seek for modification of the interim order upon filing a statement of objections. You file your statement and seek. We are scared in this service matter because one matter we do, thousands of others will come up. Let us see.
The petition. For consideration of interim privilege.
Who is the answering respondent?
That's answering respondent is the interesting authority, which is the government.
Government. What is this matter?
They've challenged the endorsement order passed by the first respondent. The second respondent, Lokayukta, against the petitioners. That's it.
But what is the point you're raising so that at least they look into?
There is entrusting the inquiry, at the hands of the Lokayukta. There is non-application of mind as mandated by Section 12 of the Karnataka Lokayukta Act. In the previous round of litigation, the coordinate bench of this honorable court, on the very same ground, had allowed the writ petition of the petitioners.
Let us see the observation. Case
Starts at 187, annexure N.
Yes.
The observation, is at page 191, paragraph 6.
Yes.
I've given my anxious consideration to the rival submissions advanced by the parties and entertain this the said plea of non-application of mind on the part of employer in entrusting inquiry to the hands of Lokayukta, as it is now well settled by plethora of judgments of the division bench of this court that order of entrustment of inquiry should bear application of mind, which is the mandate of Section 12(4) of the Act, which reads as follows. The Act is extracted. In terms of the extracted Act, Section 12(4) of the Act, the competent authority has to examine the report furnished under Section 12(b) of the Act and then entrust the inquiry to the hands of the Lokayukta. The examination of the government in the case of in the case at hand purported to be under subsection 4 of Section 12 of the Act is in terms of the impugned order dated 4/12/2017, which was the previous entrustment order. That previous entrustment order, my lords, is extracted, and my lords may come to page 195. The impugned order does not particularize or analyze the misconduct of each of the employees, but barely repeats whatever report furnished by the Lokayukta under subsection 3 of Section 12 of the Act. The preamble of the impugned order also does not indicate what went into the decision making of the entrustment of inquiry to the hands of the Lokayukta. A mere repetition of what the Lokayukta would say would not suffice for the impugned orders to be in tune with subsection 4 of Section 12 of the Act. In my considered view, the order of entrustment bears the stamp of non-application of mind. And my lords, various judgments of the Honorable Division Bench and Coordinate Benches are extracted. Thereafter, my lords, the writ petition, the order, my lords, is at 207, the operative portion. Petition is allowed. The entrustment previous entrustment order is quashed. However, liberty was given, my lords, for the decision to be taken in compliance with Section 12(4) of the Act. Now, my lords, annexure P is passed, which is again a replica of the previous entrustment order. The only extra paragraph that is added here is the order of the coordinate bench.
Let us see. You file your objection. You file your objection.
Lords,
Now, we can't, now these matters, every instance if you keep coming and interrupting the inquiry, there's no end.
my lords, originally what has happened is the complaint was not even against the
So
petitioners herein.
let us see now what's
My lords, the original complaints
No,
against whom it was, they have
we'll
been
consider-
left scot-free.
we'll consider it. Let him file objection. In the light of the objection, we'll decide whether
My lords,
there's
one difficulty is, my lords, the first respondent is due to promotion. My lords, this may come in the way.
we can't do, it will have to be in sealed cover, that's all. We can't quash it there without hearing the other thing. Let us see. Statement of objections to be filed by the respondents. List the matter week after next.
Lords, until then, if I may pray, my lords, at least for them not to precipitate, my lords.
You have
The
already,
order says 6 months early inquiry, Mukshi,
You have
they are
already-
also on.
you already had the benefit of one time. Second time, let us examine it. I am not ruling out what orders to be passed, but let us see.
Please.
Yes. Pension, is it? What ground it was rejected? On what ground it was rejected?
On ground like it was met on an accident and based on CC pension rules, from basis of invalidation from service, like his pension was not being given with respect to service loss, salary loss, and loss of promotion as well. So we are requesting for certiorari quashing, writ of certiorari quashing annexure K and annexure B, and also writ of mandamus against annexure N.
Request made on behalf of the respondent who submits that the instruction would be complete by the next date. Relist the matter week after next day. Objections, if any, to be filed within the next 2 dates. Next dates. 2 weeks.
Request in this matter, my lords. My name may be
Yes.
deleted. My learned friend is appearing in the matter, my lords. Mr. Basuraj is appearing, my lords. My name may be deleted.
Office to delete the name of learned counsel, be promoted.
Much.
The response. Yes.
Much.
Appear, my lord. My lord, it's a case of a Group D employee, a driver, my lord, in the municipality who has services, though he worked up to the date of retirement, services were not regularized. He approached this honorable court, my lord. Notice has already been ordered, my lord, but I am submitting because this is third round of litigation. I have served the notice on all as directed by this court, my lord, duly on the all the council. And summons have been duly served, my lord. And filed also along with a memo on 13/9. May I submit, my lord?
So let them take. Now you take a stand. Page. Now who appears
My lord,
for the city municipal council? Who appears?
Anand. When Mr. Anand appeared on the last occasion.
No name is shown in the cause list. So who appears for that R4?
After we have served on the council by name, by hand summons to the municipality, we have served. TMC I have served by month.
Let us see if somebody comes by the next date.
Next week, yeah. Date may be given as well.
Relist the matter. There's no standing council, is it?
No standing council. These are able to change. If they will, I will serve my lord. If there, I will serve. If the lordship permit me, I will also serve extra copy on the council.
Petitioners at liberty. Petitioners at liberty to serve standing counsel, if any, for the 4th respondent. Is the matter week after next.
19
Date?
Week after next.
Yes.
yesterday matter. The Anganwadi teachers.
Could you- Now, what is the contention? Contention is no. What is the rule? Rule is if it is
Only three.
no. What is the benefit they're claiming that they should be no? You should give preference to those. What is the
3 kilometers.
if they're within 3 kilometers? Entitled for what? Without calling for recruitment notification or promotion. Now, which is that rule? Let us have a look at the rule.
Annexure C.
No, this is the distance, sir. But that preference rule.
Annexure C.
Annexure
C. Page number 25.
page
Page 25. C.
yes.
ತಿದ್ದುಪಡಿ ಮಾಡಲಾಗುತ್ತದೆ. ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಹುದ್ದೆ ಖಾಲಿ ಇರುವ ಹೊಸ ಕೇಂದ್ರ ಪ್ರಾರಂಭಿಸುವ ಗ್ರಾಮದ ಯೋಜನಾ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ವಾಸಿಸುತ್ತಿರುವ ಮಿನಿ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆಯರಿಗೆ ಅವರು ಆ ಅಂಗನವಾಡಿ ಕೇಂದ್ರದಿಂದ 3 ಕಿಲೋಮೀಟರ್ ವ್ಯಾಪ್ತಿಯೊಳಗೆ ವಾಸಿಸುತ್ತಿದ್ದು ಕಾರ್ಯಕರ್ತೆ ಹುದ್ದೆಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದಲ್ಲಿ ಆ ಅಂಗನವಾಡಿ ಕೇಂದ್ರದ ಕಾರ್ಯಕರ್ತೆ ಹುದ್ದೆಗೆ ಬೇರೆ ಅಭ್ಯರ್ಥಿಗಳಿಂದ ಅರ್ಜಿಯನ್ನು ಆಹ್ವಾನಿಸದೆ ಆದ್ಯತೆ ಮೇರೆಗೆ ಸದರಿ ಮಿನಿ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆಯನ್ನು ಸಾಮಾನ್ಯ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಹುದ್ದೆಗೆ ಆಯ್ಕೆ ಮಾಡತಕ್ಕದ್ದು.
What is this mini Anganwadi?
Annexure C. B. She is appointed as mini Anganwadi teachers in the all early village.
Annexure B.
Annexure B. Page number 21.
Yes.
Mini Anganwadi teachers. Serial number 2. All early. Srimati Manjula Hanumanthappa, she is appointed as a mini appointed. Now present it is a Vilagali, it is a vacant place for the Anganwadi Karyakarte.
At Bilagali.
Vilagali. It is Sarvata, it is 3 kilometers from the place.
Where is that notification? Where is that notification? Where is the notification?
Call for annexure K. No, call for the appointment. Annexure K. Page number 39. On 16/8/2022. ಗ್ರಾಮ ಪಂಚಾಯತ್ ಪಟ್ಟಣದ ಶೆಟ್ಟನಹಳ್ಳಿ ಅಂಗನವಾಡಿ ಕೇಂದ್ರ ಹೆಸರು ಬೆಳಗಲಿ.
Bilagali.
ಬೆಳಗಲಿ.
Now, Child Develop Shishu Abhiruddhi Yojana Adhikari is Project Development Officer. Huh? Now the certificate. Now the certificate of distance you have obtained from annexure age 30.
Page 38. ಅಥವಾ ಲೋಕೋಪಯೋಗಿ ಬಂದರು ಸಾರಿ ಇದರಲ್ಲಿ ವೆರಿ ಐ ರೀಡ್ ಔಟ್.
Yes.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಅರ್ಜಿದಾರರು ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆಯಾಗಿದ್ದಲ್ಲಿ ಬಡ್ತಿ ಉದ್ದೇಶಕ್ಕಾಗಿ ಸರ್ವಾ ತಾಲೂಕು ಆಲವಳ್ಳಿ ಗ್ರಾಮದಿಂದ ಬಿಳಗಲಿ ಅಂಗನವಾಡಿ ಕೇಂದ್ರಕ್ಕೆ ಇರುವ ಅಂತರವನ್ನು ದೃಢೀಕರಿಸಿಕೊಳ್ಳಲು ಉಲ್ಲೇಖ ಪತ್ರದಲ್ಲಿ ಮನವಿ ಸಲ್ಲಿಸುತ್ತಾರೆ. ಅದರಂತೆ ಸರ್ವಾ ತಾಲೂಕು ಆಲವಳ್ಳಿ ಗ್ರಾಮದಿಂದ ಬಿಳಗಲಿ ಅಂಗನವಾಡಿ ಕೇಂದ್ರಕ್ಕೆ ಸರ್ವ ಋತು ಮುಖ್ಯ ರಸ್ತೆಯ ಮುಖಾಂತರ ಸುಮಾರು 6.5 ಕಿಲೋಮೀಟರ್ ದೂರ ಇರುತ್ತದೆ. ಆದರೆ
ಗ್ರಾಮ ಪಂಚಾಯತಿ ತಲಗಟ್ಟೆಯು ದೃಢೀಕರಿಸ ನೀಡಿರುವಂತೆ ಗ್ರಾಮೀಣ ರಸ್ತೆಯ ಮೂಲಕ ಹಾದು ಹೋಗುವ ರಸ್ತೆಯ ಅಂತರ 3 ಕಿಲೋಮೀಟರ್ ದೂರವಾಗುತ್ತೆ ಎಂದು ಈ ಮೂಲಕ ದೃಢೀಕರಿಸಲಾಗಿದೆ. This is Lokapi also admitted that 3 kilometers from the Belgavi to.
Now this can be reconsidered. What we can say, let the PWD reconsider. Reconsider annexure J, because they have, in terms of that, they have mentioned both. Let them reconsider. Till then, you keep the recruitment on hold. Now, which is the other certificate which you rely on for distance?
Yesterday one, along with document.
Annexure
G.
What does it say? So we'll ask the PWT to re-examine. The petitioner stated to be a mini Anganwadi worker.
Mini Anganwadi character.
What is this mini Anganwadi worker? Huh? Mini Anganwadi worker appointed as per the order
Dated 5/11/2012. That's a female.
dated 5/11/2012 as per annexure B. Name of the petitioner is found at serial number 2. The address of the petitioner is shown as Alahalli. So what we'll say, that in light of they having also referred to the Gram Panchayat measurement of distance, let them re-examine it, because there are distance, I'll say, mentioned, the address of the petitioner is mentioned as Alahalli. The petitioner submits that in terms of amendment made to the selection of, to the guidelines relating to selection of Anganwadi worker / assistant dated 15/6/2020. In the event a mini Anganwadi worker is already working within the radius of 3 kilometers of the proposed new Anganwadi center. In such event, new or vacant, in such event, preference is required to be given to such mini Anganwadi worker. Preference
should be given without calling the appointment.
Where do you get without calling for it?
ಅಲ್ಲೇ ಮುಂದೆ ಕಂಟಿನ್ಯೂ ಬೇರೆ ಅಭ್ಯರ್ಥಿಗಳಿಂದ ಅರ್ಜಿಗಳನ್ನು ಆಹ್ವಾನಿಸದೆ ಆದ್ಯತೆ ಮೇರೆಗೆ ಸದರಿ ಮಿನಿ ಅಂಗನವಾಡಿ ಕಾರ್ತೆಯನ್ನು ಸಾಮಾನ್ಯ ಅಂಗನವಾಡಿ ಕಾರ್ತೆ ಹುದ್ದೆಗೆ ಆಯ್ಕೆ ಮಾಡುತ್ತಿರುವುದು. Without call for the
where are you reading that?
25 ಕಂಟಿನ್ಯೂ ಅದರಲ್ಲೇ ತಿದ್ದುಪಡಿ ಆಯಿಸಿದೆ. ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಹುದ್ದೆ ಖಾಲಿ ಇರುವ ಹೊಸ ಕೇಂದ್ರವಾದ ಗ್ರಾಮದ ಯೋಜನಾ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ವಾಸಿಸುತ್ತಿರುವ ಮಿನಿ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಅವರು ಆ ಅಂಗನವಾಡಿ ಕೇಂದ್ರದಿಂದ 3 ಕಿಲೋಮೀಟರ್ ವ್ಯಾಪ್ತಿಗೆ ವಾಸಿಸುತ್ತಿದ್ದು ಕಾರ್ಯಕರ್ತೆ ಹುದ್ದೆಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದೆ. ಆ ಅಂಗನವಾಡಿ ಕೇಂದ್ರದ ಕಾರ್ಯಕರ್ತೆ ಹುದ್ದೆಗೆ ಬೇರೆ ಅಭ್ಯರ್ಥಿಗಳಿಂದ ಅರ್ಜಿಯನ್ನು ಆಹ್ವಾನಿಸದೆ ಆದ್ಯತೆ ಮೇರೆಗೆ ಸದರಿ ಮಿನಿ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆಯನ್ನು ಸಾಮಾನ್ಯ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆಗೆ ಆಯ್ಕೆ ಮಾಡುತ್ತದೆ.
Yes, yes.
Such event, preference is required to be given to such mini Anganwadi worker.
And if the mini Anganwadi worker and the mini Anganwadi worker is to be selected without calling for fresh applications. Fresh applications. Next, the petitioner submits that the petitioner is a resident of Alahalli and the proposed Anganwadi center sought to be set up at Bilagali is within 3 kilometers and refers to the and relies upon the certificate issued by the
Made a representation to the third respondent.
and relies upon the certificate at Annexure G issued by
The Gram Panchayat.
by the Gram Panchayat. Which Gram Panchayat? By the Gram Panchayat. Full stop. The learned AGA submits that in terms of the notification dated 18/8/2018, which are the applicable guidelines. As per guideline number 7, which reads as follows.
One submission is the appointment of Anganwadi helper and attendants is not Anganwadi Karyakarta, it is different. Anganwadi helper appointment is different. It is Anganwadi Karyakarta, it is Anganwadi helper and attendants is notification. The memo is.
Helper and attendant.
No, sir.
Okay. AGA relies upon in the beginning.
Third, AG submits that in
Helper
terms of the notification dated 18/8/18, which are applicable guidelines as per guideline number 7.
Upon the guidelines applicable to appointment of Anganwadi helpers and assistants. Karyakರ್ತೆಯರು ಮತ್ತು ಸಹಾಯ. Where is that? Where do you get that this is applicable only to helpers and?
ಮೊದಲು ಹೇಳಿದೆ.
ಅಲ್ಲ ಅದರಲ್ಲಿ but
Not sort of meaning.
let us see. Guideline applicable to Anganwadi workers and assistants. As per guideline number 7, the calculation of distance is as per the opinion of the child development officer, child development officer or officials of the public works department. EGA points out to the Annexure Annexure J, which is a certificate issued by the PWD department dated 10/8/2022, wherein it is opined that the distance from Alahalli village to Bilagali Anganwadi center through the Sarvarutu main road is about 6.50 kilometers. Full stop. In the said certificate, it is also opined that as per the certificate issued by the Gram Panchayat, distance as per the rural road, Gramina Raste, rural road, distance would be 3 kilometers. Full stop. Next. What needs to be noted is that the rule that is made for giving preference to mini Anganwadi workers is for the benefit of those who are already working as Anganwadi workers. Any interpretation to be placed on the rule must be for the benefit of such person who is otherwise eligible. The interpretation of distance, the distance that is required to be certified by the PWD is not forthcoming with certainty, since as per the certificate at Annexure J, both distances from Sarvarutu Main Road being 6.50 kilometers, as well as the distance in terms of the certificate issued by the Gram Panchayat, that is 3 kilometers, are mentioned. The PWD is required to take a stand with respect to the distance without any ambiguity. It is also to be noticed that there cannot be any ambiguity with respect to a quantifiable data of distance. And if the rule mentions distance to be of 3 kilometers, PWD is to keep in mind the tone and tenor and spirit of the said requirement and mention the distance with accuracy. Full stop. It cannot be that the Gram Panchayat certificate on distance is different from the PWD's measurement of distance. Accordingly, the endorsement at Annexure J is set aside. In the consequence, the notification at Annexure K is also set aside, as well as the endorsement at Annexure H. The question of the respondent number, question of respondent number 3, re-notifying as has been done at Annexure A can be made only after an unambiguous finding is given by the Public Works Department. Full stop. Correct, but now then I'll keep it in abeyance. I'll keep it in abeyance.
lost it.
Right. No, correct. Now if they come, then it becomes complicated. The last paragraph delete J is set aside. That means to be reconsidered. J set aside, full stop. The notification at Annexure A is to be kept in abeyance. Till the certification of distance by the PWD. Or PWD or the field development. As per your guideline, both is. Till the PWD or child development officer gives a report regarding the distance. It is always open to the government to issue appropriate directions relating to measurement of distances if required.
Appear for now, this matter last occasion I sought for an interim order because the articles of charges, my lord, page number 29 is served on 21/6/22, my lord, whereas the event relating to the charge is 2006.
Just one. Just one.
And under 214, my lord, the Inquiry is without authority and competency, my lord. Therefore, the entire proceedings now initiated are liable to be set aside as being incompetent, firstly on the ground of delay that 214 contemplates that if your lordship permit, I will read those.
No, let us see. They want to file their objection. I'll have it.
Our
week after
objection
next.
file model. In the meanwhile, inquiry may be stayed because it's a patently void order. That is what. If on merits I am arguing regarding evidence, nature of charge,
No,
then
you
your
get
lordship.
instruct.
But when I'm saying
No,
it is incompetent,
You get
and for 15
instructions.
years, wait.
Just 1 minute. Just 1 minute. No, you get instructions on the interim prayer. Either you file objection, I'll give you a last chance. You either file objection or you get instructions regarding the interim prayer and make submission by the next day. At,
Sir, 2 weeks.
request,
Till
let
they
us-
file the reply statement, my lord, your
No, let
lordship
us-
may say because
I'm
they
not
have
going.
62
We are not going to wait. We are not going to wait till they file the objection. Let them come with preliminary objections by the next date orally, and we'll decide the preliminary. The consideration of interim prayer is kept open till the next date. Learned counsel so and so, appearing for respondent number 2, submits. Instructions will be completed by the next date. Relist the matter on.
for consideration of interim order, my lord, the final.
For consideration of interim prayer
Yes.
on 30th. 30th. You get instruction. If you can't file objection by then, at least you must get instructions.
On the
Because
face of the
you're not
order, I can show it.
you're not on keyboard. So you have to come ready by it. Yes.
Yes.
Let us see. We have passed over that matter. The director has come. Let us see at 1 o'clock. Yes. Yes. Weeks time granted for necessary compliance. Yes. ಇದು ಆಗಿದೆ. ಅದೇನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇನ್ನೂ ಕ್ಲಿಯರ್ ಆಗಿಲ್ಲ.
ಪರ್ಮಿಷನ್ ಲೆಟರ್ ಹಾಕ್ಬೇಕು ಅಂತ ಗೊತ್ತಾಗಿರ್ಲಿಲ್ಲ ಮೈಲಾಡ್, ಹಾಕ್ತೀನಿ ಮೈಲಾಡ್. ಮೈಲಾಡ್
ಡೇಟ್ ಕೊಡ್ತೀವಿ.
this month 27 and 28 ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಟ್ರೈನಿಂಗ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಮೈಸೂರಲ್ಲಿ ನಂದು ಮತ್ತೆ ಇಂಟರ್ವ್ಯೂ ಇರೋದ್ರಿಂದ 27 ಮತ್ತು 28ನೇ ತಾರೀಕು 2 ದಿನ ಬಿಟ್ಟು ಬೇರೆ ದಿನ ಡೇಟ್ ಕೊಡಿ ಅಂತ ಕೇಳ್ತಾರೆ.
Relist the matter on 10th of October. Yes.
Last case, you cannot respondent that will not the outer limit within
No, Terry. What was the stand taken in that?
last time my lord should see the affidavit that is filed on 8/9/2022. But there is no definitive stance that has been taken for the time period. My lord should turn of that affidavit 6 and 7. What has the affidavit? 8/9/2022.
So
Para 6 and 7 will not vary
8/9.
2022. Last 8 notes I filed it. 1905 first it.
905.
1905 filed in open court.
Affidavit here.
Para 6 and 7 notes. 6 notes. That the company has prepared restructuring competitiveness enhancement plan approved by Board of HMT Machines Limited and Board of HMT Limited, holding company of HMT Machine Tools Limited, and is under consideration of Ministry of Heavy Industries. The proposal includes addressing the statutory dues, settlement of dues to its employees, repayment of Government of India loan, dues to banks and holding company loans, to sale transfer of land 46 acres at Bangalore, which was earlier approved by CCEA, and the probable buyers are GST, income tax, and EPFO. And as such, the gratuity dues payable to the eligible employees would be addressed once the plan is approved, and as such requested the petitioner to await the consideration of the respondent regarding the proposal made to MHI. This last portion, my lords, makes it very contingent. They do not, my lords, specifically undertake. They say when this plan is approved, my lords, that is when they will pay. Paragraph 7, my lords, I submit that as per order dated 24/8/2022.
Government.
Just one.
Passed by this honorable court in the above writ petition. This respondent company is herewith undertaking that company will maintain the seniority-wise payment disbursement. Regarding 1992 arrears, pending payment is made up to 2015 on seniority basis in the year 2022. And after many years of effort, company has adjusted the payment of 1992 arrears now. In this regard, the applicable earned leave encashment amount and 1992 wage arrears in the above cases will be payable on successful financial help from the Government of India, Ministry of Heavy Industry, or availability of fund adjustment mentioned in the above paragraph. Here also, not they make it contingent. They do not say, my lords, when they will clear it. They say, my lords, when the plan is approved, they will come up and pay, my lords. That was not, my lords,
No, then you find out from the central government what is it. If you want them to be made a party, we'll make them a party also. So let there be some definitive stand.
this one is a central government company.
Make party. Will make party.
They will make let
Yes,
them-
my lord, I will serve the AC's office, but my
let us see. So in presence of all,
yes,
we'll have something recorded. Otherwise, no purpose will be served by it.
yes, my lord, because for a instrumentality of the state, my lords, to deny what is rightfully mine, leave encashment, my lords, for years together, without there being a fixed time limit, my lords, is completely unfair. In fact, my
But
lord,
what is the progress that is made for realization of the fund? At what stage that proposal is there? What is the before the central government? When proposal was sent? Now let them come on record. Let the central government also come. And then we'll
because there
pass.
has to be some closure, my lords,
Yes.
because for keep it pending for 10 years. And on top of that, my lords, my pension is 1,000 rupees because of the EPFO scheme, which is now pending before the Honorable Supreme Court. My pension, my lords, is at a mere 3,000 or 4,000 rupees because they're not considering my pensionable salary as my actual salary because of the cap in the pension scheme. I'm making 4,000 rupees as pension after putting in 30 years of service. And on top of that, I'm not being given my dues for EL. I've not even been paid my gratuity. My lord. In fact, on behalf of some of the petitioners who are before your lordships, I am again constrained to file a contempt. I get them for payment of gratuity, not even other dues. Gratuity, my lords, also they are not paying. And here, my lords, the stance is that we will pay after clearance of gratuity, which will never happen because gratuity dues are never cleared. And they will say that EL will be paid after gratuity. This rate, my lords, the money is never going to.
Let the central government also come.
Yes, my lords, I understand. I will implead the central government.
No, but some arrangement will have to be made. You can't continue for years together. Your group companies are making profit. Only HMT, other group companies are profit making, isn't it? Let us see. The affidavit, peruse the affidavit filed by the general manager, MBX, pursuant to the order of this court dated 24/8/2022. At para 6 of the affidavit, it is stated that the company has prepared restructuring competitiveness enhancement plan approved by the board of HMT Machines Limited and the board of HMT Limited and is under consideration of Ministry of Heavy Industries. It is submitted that once such plan is approved, the request of the petitioner would be considered. There is no statement made regarding the time within which such proposal would be cleared by the central government, enabling them to consider the claim of the petitioner. This period to bring a quietus to the claims of petitioners and other employees similarly situated, to implead the Ministry of Heavy Industries as an additional respondent. So, accordingly, now who do we have to, what is the nomenclature?
Represented by the Ministry of Heavy Industries.
What is the nomenclature? Accordingly, the Ministry of Heavy Industries, represented by Secretary, is permitted to be included as additional respondent. Necessary amendment is carried out. Learned Counsel Sri M.N. Kumar undertakes to appear on behalf of the said respondent. Now we carry it out. Now it's.
I'll carry it out now. I'll also file an amended petition.
Yes.
I'll have a copy.
Relist matter on 29th in the same stage. Now the only question is, there are some benefits payable to the employees of HMT, and they say that there is some proposal that is pending before the union government. Once that restructuring plan is approved by the Ministry of Heavy Industries, they can consider the claims of the petitioners. So we want to know at what stage it is. Is there any timeline within which it may be? Yes. Or at least till that plan is approved, if there's any possibility, you look into it. That is the only point on which we want you to intervene. Now you carry out amendment, immediately give him a call.
All four petitions. Only the first 8 petitions.
Now we'll.
All four are connected. All four are connected. Like carried out in all four amendments or only in the
Okay, carry it. The implead order of implead. Now anyhow, it's a common order sheet, isn't it? Amendment to be carried out in all the petitions. You give him a copy.
Yes.
25, CLIA.
Yes.
The petition has been appointed in the year 2019, and after nearly serving for 2 years, he has been not avoid the termination. When he has voluntarily has not resigned, the principal, the college has
Not given full set of papers. But up to page 39, it's available. But from 40 to 69, legal notice and all. It is not furnished.
Give a full set. Give a full set of papers. The petition ends at page 60.
69.
Yeah, 69.
Plus, it's available only 44.
Give a full.
It's only 44.
But index refers 69.
So it is wrongly mentioned.
Legal notice copy is not.
The court paper also is still 69. Please check. Give him a complete set of it. Relist the matter week after next. A full set of papers to be served on R1 to R2. Yes.
I will give it half. Because the petitioner is already vested one academic year. That has been withheld by the institute. Original MD's convocation certificate has been withholded, because of which he couldn't apply for the last academic. Now, new academic year, we start from last year. So there is an interim prayer here to release for the mass card. So if the honorable my lord
Itself is not maintainable. Look at the prayer. The prayer is only to furnish the original master degree certificate. But if we tender this resignation letter and approach the principal, he doesn't want to withhold this degree certificate. We'll issue. We'll return the documents.
No, now you don't want to continue, isn't it?
He doesn't want to continue.
Your lordship, he has been told to resign, and after that he was blocked from entering the premises in the month of September 2021. It was not that the situation here, it is not that he was not willing to serve the institution. He was told to resign in the first week of September, and when he does not tender the resignation, then his biometric was discontinued, is blocked. All official email IDs were blocked, and in the third week of September, the security has stopped him from entering the premises.
So now you have been terminated, or just it's overload?
This institution is having a practice of not issuing the appointment letter, and even they have not issued the termination letter. The sole reason is, if you are issuing the termination letter, you have to give the 3 months salary. So in order to avoid the termination benefits, they have told him to tender the resignation in the first week of September. When he asked to officially convey, because he doesn't have any history of any kind of indisciplinary activities in the institution. In fact, he was even given the charge of HOD because of his good academic record.
Now what is your relief? What is the relief that you want now?
Your lordship, because of this unlawful activity of the institution, he was not given the September month salary. He was, in spite of repeated emails, which we have attached in this petition, and also legal notice. The respondent, he even not bothered to reply. They were even not taking his calls. In fact, when I went to view the summons, in fact, the huge drama happened for an half an hour. Even the principal was not ready to talk to me. When I am repeatedly saying it's a question of petitioner's life, and we have filed a writ petition, and we have just come to serve the handsomens. So the relief, which because of this activity, first of all, he was not given the termination benefits. He was not given the original mass card, experience certificate, leaving order, because of which he couldn't apply in the month of in the last academic year. He could have at least explored in the other college. So almost 1 year he struggled to earn his livelihood.
So now what do you want now? What do you want now?
Interim prayer, we have completed this honorable court to issue direction to the respondent to give relieving order his personal mass card, master engineering certificate, civil department, and experience certificate. So the prayer, we have only prayed that because of the unlawful activities of the respondent, the petitioner has lost his livelihood and he was subjected.
Now, insofar as your main prayer for compensation, I will keep it open for you. You may have to go to the civil court. Insofar as the other relief, we'll ask them to give the documents. Insofar as whatever compensation you are claiming, I'll keep it open for you. You can go to the civil court. The remaining, we'll ask them to take your resignation letter and give the certificates within a week from today. And we'll just one. And we'll dispose it off.
Actually, it is not a question. This is not a case.
No, what I'm saying, your certificates will direct them to give it within 1 week. So there ends the matter insofar as your grievance relating to your original certificates. Any remaining,
Relieving certificate.
all that will direct them to give it. Then is there any other relief that you want in the writ, or if they give it within a week, there ends the matter. If anything else you want, you may have to go to the civil court. But the certificates within a time limit we'll fix and we'll ask them to give it. There is.
Lordship, I could have approached the civil court under the educational.
No, not for the compensation what you are claiming. Now the certificates we'll give your certificates within 7 days or 10 days. That will order. There you give the resignation, they will accept it and give it. If there is any other grievance, you take it before the civil.
Your Lordship, actually, I have come to the High Court basically on the violation of human
Correct, madam. But I'm saying that insofar as there are certain disputed facts, no doubt the court has power to grant compensation for violation of fundamental right. But because its factual disputes are there, we cannot decide that. That you go before the civil court. Your other prayer with respect to certificates, we'll ask them to give. And then we'll close it.
They're not even saying what is.
That I'll pass a direction, don't worry. I'll ask them to give their certificates within a time limit. Remaining prayer of compensation for loss caused to you, I'll keep it open, then you can work out your remedy as per law. Insofar as certificates, I'll pass an order and we'll close the matter.
Your Lordship, even he has not got the salary of September.
That we'll ask. That salary for whatever period you have worked, we'll ask them to pay. Then we'll ask them to give all your certificates within a time limit. Remaining relief, whatever you want, I'll keep it open for you to take it up before the civil court.
We will not award the compensation.
It has jurisdiction. Where disputed questions are involved, you can go before the civil court.
They are not issued any.
Now what do you want, madam? You want your certificate, I'll direct them to give. Compensation, we can't decide. That you go before the civil court because they are disputed questions. You take care, tell me what you want.
First instance,
That will order. That will be done. That will order. Now the remaining relief what you have sought for compensation, that you have to go before the civil court, that I can't decide. For wages relating to period that you have worked, I'll direct them to pay. Yes. How much? So we'll ask them to approach you to give a.
Your Lordship, my client's submission is. Your Lordship, my client's submission is. There is no question of submitting the resignation.
No, you want your certificate, isn't it?
Of course, but he want to continue.
You want to continue? No, we'll ask him if they are ready to continue. We'll ask them. We'll ask them. Then you get instruction. Just get it. And they want to. You want to continue or not? Then let them consider it. You get instruction. You get. Let us see. You find out. Objections, if any, to be filed within 2 weeks. Just the matter after 2 weeks. Yes.
I appear for the petitioners in this case, my lord. This is a matter pertaining to compassionate appointment, my lord. All the 4 petitioners have filed applications for compassionate appointment on the grounds of compassionate appointment from the year 2012 onwards, my lord. However, the respondent corporation has been ignoring their repeated representations, and also they have not taken any decision on their applications thus far, my lord. The excuses that the
Take out notice.
now suddenly there is a notification for direct recruitment, my lord, and till now they have been telling us there is no vacancy, we are a loss running corporation, we cannot accommodate new people, but they have now called for direct recruitment for several posts, my lord. However,
that
my
we'll
application
see. That we'll see. We'll direct them to this will be independent of that. That we'll see.
oblige, my lord.
Learned. AG accepts notice for respondent 1-3. Learned Council NK Ramesh directed to accept notice for the 4th respondent. Karnataka State Seeds Corporation.
Yes,
Emergent notice. Respondent number 2, petitioners permitted to take out notice by way of hand summons to the 2nd respondent. List the matter week after next.
Oblige, my lord. There is an interim prayer I have sought with regard to.
Office objections are kept open.
There is only one objection, my lord, regarding filing the original copy of the annexure that I'm challenging for direct recruitment, my lord. I have received that from the website of the corporation, my lord. So that may kindly be.
Office objection is overruled.
Much obliged, my lord. There's an interim prayer I'm seeking with regard to.
See, let them first consider your application. Then the court will mold relief accordingly. Let us.
Oblige, my lord. Much obliged.
Yes.
File is being transferred has got 11 months. They've transferred respondent number 5 back to his original place solely based on the order passed by the report. Thing is, because the order has been passed, the order available at annexure J page 30.
So who's for R5? No? Let us see. Now, R5 notice in
That's so we also the reward to serve strategic object for the petition. The C was served. Take one was served. That may make this sufficient. The finality to this particular litigation.
No, last time he made some interesting proposal, saying that if you accommodate him, then he is not interested in challenging the. So. Correct, or some place nearby, you will be satisfied. You do some.
I have given the representation that my soul.
No, what I'm saying, you settle it. Now you find out where he wants. If he's agreeable and it's vacant, there ends the matter.
Yes, I think
so what is, so tell me, what is it? No, what, first, what is it now? What has happened now? So now you have ordered to at Nanjangud. Now he has been displaced to his original place at Mysore. Now where do you want him to go?
So we've given the letter at page 30. Even post to Nature Works Division, Mysore.
Annexure?
page 35.
Hmm.
While I taken two issues, my lord, saying that number one, hear me out before you transfer. The second one, I've also got to the notice of people saying, I mean, on the PPTCL, saying there are other posts within the division. Kindly consider.
Within Mysore division.
Which were specifically termed as AO post to major works division.
We can only say Mysore division. We can't say particular place because we don't know. Mysore division, let them see and we'll direct them to examine that. In Mysore division. In Mysore division. Yes. Now you appear, isn't it? The petitioner has challenged the order at annexure.
Questioning the transfer of
In order at annexure A, dated 3rd September 2022, whereby the fifth respondent has been retained at Nanjangud, has been
reposted back to transferred back to Nanjangud.
has been reposted at Nanjangud, displacing the petitioner. Though after hearing the matter for some time, though various contentions have been made, petitioner submits that if any order for posting is considered as regards for the petitioner in the Mysore division, his grievance would stand addressed.
Is that there are certain posts? What
It submits that and further submits that in terms of the notification of 7/9/2021, there are certain posts vacant in the Mysore division. Learned counsel appearing for the KPTCL submits that KPTCL submits that the providing of posting of the petitioner in Mysore division would be considered in any of the vacant posts. Recording such undertaking, petition is disposed of. Notice to R5 is dispensed with as the grievance of the petitioner.
That's Mysore division.
Recording such undertaking, petition is disposed of. Notice to respond number 5 is dispensed with as grievance of the petitioner.
Is only limited to providing of posting in Mysore division. For transfers, there is no counseling process. No. Yes. D. What is it? Exit out. Registry to verify and list the matter before the appropriate roster. On Monday, as counsel for the petitioner submits that there is some urgency in the matter. Sign mark principle. Why are they clubbed?
Petition what they have filed. In that, the very same petitioner in these criminal two petitions and also same things are referred there. And they have sought relief against the very same petitioner in these two criminal petitions, that petition also. Only by the office bearers of the same association. He is also secretary of that as well. The offense involved in this case is relating to the annual performance appraisal report in respect of respondent number 2 was appraised to the reviewing authority by the petition in those two cases. That is the offense what he is making. It is not private in nature. It is a connection with the discharging official duties of the petitioners in both the cases. They have referred this petition and also they want to buttress their argument in the criminal petition against the petitioner in this case. That's why it has been clubbed.
Separate. ಅದು ಅಸೋಸಿಯೇಷನ್ ಕಡೆ ಮಾಡಿರುವಂತದ್ದು. ಸೊ ಇದು ನನ್ನ ಪರ್ಸನಲ್ ಇದು. ಹಾಗಾಗ್ಬಿಟ್ಟು 29 ಮಾತ್ರ ಈಗ ತಗೊಳ್ಳಿ, ಮತ್ತೆ 29 ಸಪರೇಟ್ ಆಗಿ ಮಾಡಿ, 29 ಸಪರೇಟ್.
But so far as the criminal
ಸಪರೇಟ್ ಆಗಿದೆ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
The criminal petitions are concerned, that is relating to some proceeding before the trial court, which are sought for quashing. Anyhow, there is an interim order.
Yes.
Now we can send that back to the appropriate roster, and this we will hear it separately.
Now, issue here is, my lords, in that those two criminal petitions, this very respondent number 2 is referring this petition, and he is trying to say that these are the allegations against me. That's how it has come. Germane to the petition itself is emanating from this petition averments.
Correct, but now it will have to be independent. It will have to be independently considered. Suppose he is trying to make a criminal offense of a civil matter. Then under 482 you can get it quashed. You have a benefit of it. You, insofar as the writ petition on the service side, separately will hear it.
But I request, my lords, to that extent, this respondent 2 may be restrained from making reference to this writ petition averments, so that I can make separately independent. Otherwise, what happens? I will be deprived of making submissions in that point, if not all together.
No, so what we will say that in insofar as set of all papers to be of this petition to be kept there for reference, but we will say that this aspect present petition will be limited only insofar as the service matters, and that one let the court decide set of these papers to be kept there for reference.
Respond 29 complete are completed. 29 are completed. Yes.
No, I'm going to.
14% he has to appear before the 14% committee, and he has to seek permission to appear.
Why not 29? Please, one minute. Why not the petitioner ನಾನು ಯಾವುದೇ ತಪ್ಪು ಮಾಡಿಲ್ಲ ಮತ್ತೆ ಇದು ಅಫಿಷಿಯಲ್ ಡ್ಯೂಟಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಹಾಗಾಗಿ ನಾವು ಇದನ್ನ ಮೇಂಟೈನಬಿಲಿಟಿ ಬಗ್ಗೆ ಐಎ ಫೈಲ್ ಮಾಡಿದ್ವಿ. ವೈ ನಾಟ್
Objections
19 ಪ್ರಕಾರ ಇವರು ಅಫಿಷಿಯಲ್ ಡ್ಯೂಟಿ ಇದು ಮಾಡ್ಬೇಕಾದ್ರೆ ಗವರ್ನಮೆಂಟ್ ಇಂದ ಪ್ರೀವಿಯಸ್ ಸ್ಯಾಂಕ್ಷನ್ ತಗೊಂಡು ಬರಬೇಕು. ಮೈ ಲಾರ್ಡ್, ಅದೇ ನಾವು ಐಎ ಫೈಲ್ ಮಾಡಿದ್ವಿ ಮೆಂಟಾಲಿಟಿ ಬಗ್ಗೆ.
Criminal case will send it back to the appropriate roster. 29.2, which is a service matter, only will be decided before this court.
We,
The rest of them, we'll see, we'll fix a date. We'll fix a date and then we'll have it. The criminal petition 1947 of 2022 and criminal petition 8337 of 2022 to be delinked and be listed before the appropriate roster bench. A copy of WP 10087 of 2022 with all pleadings to be a copy of papers in WP 10087 of 2022 would be kept for reference before the court dealing with the criminal petition 1947 of 2022. WP 10087 of 2022 to be delinked and listed to be listed separately on date. WP 10087 of 2022 to be listed on 11th. The interim order earlier granted in the criminal petition 1947 of 2022 to be extended till the next date. Both matters
8337 also interim.
and as well as
8337.
as well as interim order in 8337 of 2022 is extended to the next date. Criminal petition 1947 of 2022 and 8337 of 2022 to be posted before the roster bench.
I filed objections. Yes, filed IM. Yesterday.
1947 criminal petition.
That to be heard by the roster bench. I can't take it up. It's a criminal matter. It will be posted before the roster bench. I cannot decide on that. Now that will go before the roster bench. As a party in person appears, list the criminal petitions on our date.
Time 10 days time to file objection. Yes, filed a maintenance application. It has come 2 days back. I filed objections. After 10 days, the date may be.
On 28th, 28th, the criminal matter is posted. This matter is posted on 11th. Service matter is posted on 11th. That other matter is posted on 28th. Eleventh. Yes.
In this matter, my lord. In this matter, 30th, my lord, serial number 30 I appear for the petitioner's counsel. My lord, last time it was your lordship actually ordered it to be posted for hearing by a mistake. It is posted to fix a date, my lord. It's a case of persons, my lord, who are all today pensioners. It's a case for fixing, my lord, there was a wrong fixation of their pay scales, my lord. So the matter is of a little urgent nature, my lord. I request your lordship to hear it as early as possible.
David, I'll fix the date immediately.
This side of the vacation, if possible, my lord, your lordship may kindly hear it.
It's difficult. I'll fix a date immediately in the first week itself.
Very good.
At request, list the matter on 11th in the same stage. 11th of
That is for hearing, your lordship. That is at in the afternoon at 2:30. Then it will at least reach, my lord.
No, let it be in the. It will come in the same list. Otherwise, it won't reach. Let it be the same stage. On that day, you make a request. There may be some change.
What I would like to have the matter disposed of as early as possible. That's my.
I fixed it on 11th. It will be in the same stage. On that day, you can request for time or if the court passes over, you can take it. Let us see.
Or otherwise, my lord, your lordship may post it for hearing, my lord. I will take it.
No, hearing it won't reach. At least it's coming with your IA for posting. So on the day when it reaches, you can make a request. If I say hearing, it won't. Yes.
Very well.
Yes.
Matters. Serial number 7, Vishnu Agni.
Go to
Submission by law. The earlier order itself, these courts are reserved, 1 or 2 courts, even under the order. If there is a condition, they shall not be terminated and they shall not be removed. There is also the particular thing. Then during 2016 itself, there is an approval from the finance department as well as the other government concerned to take 400 seats. After that, there was an approval from during 2016. In that, my lord, they have taken 298 this one out of 400, 298 posts are appointed by reserving 1 or 2 posts in that particular approval. Now they are placing new equipment and without disclosing the earlier government orders and all.
Let us see. Let us have a look at the, yes. (13.5). Now this recommendation was made pursuant to the order of this court. That let us have a look at. Which is Let us have it. Yes. You have a copy of it? WP 3405 is this writ petition. Hundred and two posts were ordered to be kept in a bay without unfilled, relating to the petitioners in the writ petition, or similarly placed. But that was done only pursuant to the order of the High Court. Now these 102 posts have been kept vacant. 102 posts were kept vacant. And then reference is made to para 7 of the order. With respect to these 102 posts. So that now they have asked how to fill up these 102 posts, they have asked the government. What is the final order? What is there? Nothing is there. Then you file an affidavit. File an affidavit, then we'll see what is to be done.
Gallery is concerned.
Let us see, let us see. No, but that will not serve any purpose. You file affidavit, I'll take it on record. Now you have stated that it has to be absorbed in the main cadre and some rules have to be framed. You take your stand, file an affidavit, we'll record it. Correct? No, so you give a time, you must file by way of affidavit. We'll have it on Tuesday. Wednesday.
20th.
Wednesday.
It is Tuesday.
We'll list the matter in the same stage on 20th. And one part of it, whether some other relief can be given to them till then, that you discuss with your officer.
Equal salary.
Let us see. If 2 months you're going to be regularized, then you can wait. Let us see. Yes. Now, what is that other matter now? One more matter. That's it. 22nd. And C&R, how much time? That also you must take. List the matter on 22nd. Then there was some issue in that other matter. Similar problem, is it? Other matter also. No, correct. There also, in that other matter also, whether you can take a decision for absorption or otherwise is the question there also. No, but absorption. Who has to take a decision? Then let the government take it. Let us see. No. No, that will order. But insofar as their right to be considered for absorption, some decision must be taken. So who is the authority now to absorb? Government or the institute? Then you consider that whether they could be absorbed in terms of that. Correct. That is a decision. So let them consider till then we'll say don't repatriate. Let them consider. That's all. Consider it. Till then don't repatriate. The rest of it will be after you pass an order on merits. It's left to the parties to work out the remedy. So then otherwise you consider and you pass orders and you place it before the court. His request is pending before you. We'll have it after 2 weeks. You pass a considered order as regards that request of his. Insofar as his request for absorption, you consider and pass order. Place it before the court, we'll have it after 2 weeks. Where is your request? Annexure X.
Retained statement. No main prayer ಇಲ್ಲ ಅಂದ್ರೆ main prayer ಇದೆ. Register my case for absorption ಅಂತ ಹೇಳಿ main prayer.
Annexure X is it?
Annexure X. Page number 20 along with the 25. On 28/6/2016. That before that one, another aspect kindly see. What is the copy of the letter? I'll take notice.
The annexure X is it? Yes, read. What is it?
This is a statement made by the principal, the department, directive ಕಳಿಸಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 2 ನಲ್ಲಿ 6 ಜನ ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಈ ಕಾಲೇಜಲ್ಲಿ.
They are working at
ರೀಜನಲ್ ಪೋಸ್ಟ್ ಹೆಲ್ತ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಅಧಿಕಾರಿ ಅಂದ್ರೆ ನರ್ಸಿಂಗ್ ಆಫೀಸರ್. ಇಲ್ಲಿ ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಲೆಕ್ಚರರ್, ಪ್ರೊಫೆಸರ್, ಅಸಿಸ್ಟೆಂಟ್ ಪ್ರೊಫೆಸರ್, ಡಿಪೆಂಡಿಂಗ್ ಅಪಾನ್ ದೇರ್ ಕ್ವಾಲಿಫಿಕೇಶನ್ ಅಂಡ್ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್. ಇದ್ರಲ್ಲಿ 6 ಜನ ಇದ್ದಾರೆ. ನೆಕ್ಸ್ಟ್ ಪೇಜ್, ಥರ್ಡ್ ಪೇಜ್ ನೋಡಿ ಸ್ವಾಮಿ. ಥರ್ಡ್ ಪೇಜ್ ನಲ್ಲಿ ಫಸ್ಟ್ ಕಾಲಮ್ ಸ್ಯಾಂಕ್ಷನ್ ಸ್ಟ್ರೆಂತ್ 21, ವರ್ಕಿಂಗು 5 ಜನ. ಅಂದ್ರೆ ಇವರೆಲ್ಲರೂ ಹೆಲ್ತ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನವರ. ಇವ್ರು ರಿಪ್ಯಾಟ್ರಿಯೇಷನ್ ಎಲ್ಲ 5 ಜನನು ಕಳಿಸ್ಬಿಡ್ಬೇಕು ವಾಪಸ್. ಕಳಿಸಿರಿ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಕ್ಲೋಸ್ ಮಾಡ್ಬೋದು ಇಫ್ ದ ಗವರ್ಮೆಂಟ್ ಮೈಂಡ್ಸ್, ಇಫ್ ದೇ ಆರ್ ಇಂಟ್ರೆಸ್ಟೆಡ್. ದೇ ಆರ್ ರಿಪೀಟೆಡ್ಲಿ ಟೆಲಿಂಗ್ ಎಸ್ repatriate. Originally health and medical education are one and the same.
So you are,
After bifurcation, there was no fixing of the vacancy or options sought for by the employees had not been treated, considered.
you're saying if these 5 working people are sent back, then there's nobody.
Then there will be nobody. Then they have to close this college and treat all the students who are. There are hundreds of students, nursing students. They should be left in lurch. As far as I am concerned, I am a MSc nursing qualified person to teach the students. They want me to go as a nursing nurse in the health department.
Annexure X. What is it? So is it true that all the 5 people who are working are on deputation?
From health department. Yes, it is a fact.
Then if all the 5 are sent, you'll have to close your institute.
Yes. Let them take.
No, but he's not asking, he's saying consider. That's all he's saying. You consider it. And if just because he's coming to court, don't reject it merely because it's come to court. If he's eligible, if there's provision in law, consider it. Now you don't have anybody else. That we leave it to you. But if he is eligible, consider it. Don't have anything personal against any employee. After all, he is working here, he'll go there. If there is he's eligible to be absorbed, rules permit, he fulfills all criteria, consider it. Annexure X.
X madam. Year 1 of 2016.
So in the interregnum, you consider Annexure X, we'll have it after 2 weeks. Let us.
Yes.
After hearing it is to be noticed that the request of the petitioner for absorption, isn't it? Absorption or permanent appointment? What is it? For absorption. In the BMRCI, isn't it?
Yes, madam.
Submitted on 22/4/2015.
Annexure X
17/4/2015 is still pending consideration.
Before Director of Medical Education.
Pending consideration before the Director of Medical Education. as is evident from Annexure X. Now, this has been forwarded by the Principal Secretary to the Director.
Directly. To take a decision ಅಂತ ಹೇಳಿದ್ದಾರೆ. ನಿಮ್ಮ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಮೆಡಿಕಲ್ ಎಜುಕೇಶನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಇವರು ಸರ್ವಿಸ್ ರಿಕ್ವೈರ್ಡ್ ಇದ್ರೆ ಇಫ್ ದೇ ಆರ್ ಕ್ವಾಲಿಫೈಡ್ ಲೆಟ್ ದೆಮ್ ಟೇಕ್ ಎ ಡಿಸಿಷನ್. ಬೇಡ ಅಂತ ಹೇಳಿದ್ರೆ ಬೇಡ ಅಂತ ಹೇಳಿ. Because I have got sufficient staff, all 5 are not required ಅಂತ ಬರೆದ್ರು ಬರೀಬಹುದು.
It learned counsel for the petitioner further has by way of a memo filed a document upon which he relies upon, according to which out of the 21 sanctioned posts in the Government College of Nursing, BM Bangalore Medical College and Research Institute, only 5 working staff are those on deputation from the Ministry of
Health Department.
From the Health Department. It is further submitted that the remaining posts are vacant and said aspect may be considered, taken note of, an appropriate decision taken on the reference made to the Director of Medical Education at Annexure X. Such decision to be taken without prejudice to contentions in the present petition, if otherwise petitioner is entitled for such relief. Relist the matter after 2 weeks. Copy of the order to be furnished to the council for the state as well as the institute.
My lord, I may also be permitted to make a representation so that I can find out what are the points.
Full stop. It is further observed that the petitioner is at liberty to make further representation and furnish documents as may be appropriate, which would be taken note of by the respondent government while taking a
Government Director of Medical Education, our direction.
which would be taken note
But the
of
government
by
under
the Director of Medical Education while deciding in terms of the reference made to it at Annexure X. Yes.
In the second petition,
Presence of Indian matter, presence of the official so and so is taken note of, and their presence is dispensed with.
my lord, in this,
Yes.
my lord, in the second petition, maybe something relevant that also may kind of be considered. In the second petition, my lord, a person has been given 4 postings, not 1. She is my junior. I am eligible to work in the nursing college in Victoria Hospital, whereas a principal, in charge principal at Bowring Hospital is made to work here also. Thereby, she is a principal of nursing school, principal of nursing college, and again principal of nursing college, principal of nursing school. In 2 places, she can't discharge those duties. When there are eligible candidates in Victoria Hospital, nursing college, where is the necessity of bringing a person from another institute, which is autonomous institute?
Let us see. Just
That is second petition that your Lakshmi has to consider that.
let us see. We'll see on the next date. Let them take a decision on yours. Yes. In the previous matter, we have ordered. Previous matter lagide.
At the same time, let them also look into the second petition, my lord. That's all I can say, my lord.
You file your objections in the other second matter. In WP,
13566.
they'll file their objections to be filed in WP number so and so. In see number 7, the presence of the following officers are taken note of. The submission made upon instructions by the AGA that appropriate affidavit would be filed relating to recommendation made on 13/5/2019, whereby 102 posts have been kept vacant and outside the recruitment process. We submitted that so far as any decision regarding absorption of 102 employees are concerned, necessary rules will have to be framed or amended. Has to be framed. And affidavit in that regard, taking note of the recommendation made, would be filed by the next date. Relist the matter on 22nd. The presence of the officers are dispensed with.
So matter number 10, Sandevi.
Yes.
For the petition. I apply to appoint the Anganwadi workers. Annexure. Upon annexure, yeah. Number 7, page number 14. Chaumnalli, SC. One post.
Page?
Page number 14.
Yes. Page 17.
Serial number 17. Shanpoganalli, Anganwadi ಹೆಸರು ಚಾಮನಹಳ್ಳಿ ಶೇಕಡವಾರ ಮೀಸಲಾತಿ SC.
Number 17. Yes.
Annexure C selected my name, serial number 14. Srimati, page number 26. Annexure C.
This is the provisional list.
Provisional list.
The serial number?
Srimati Vasanta or Suresa CS Chamanalli, Ramnagar.
Serial number? Serial number?
14. Page number 26.
Yes.
The provisional list selection out of total number 26, serial number.
Then what happened?
And final list, except me, the only 25 members. Total provisional list 26. Except my final list.
Where is the list? Listed?
Annexure D.
Now you find, take inspect. Kodi.
20 out of 26 are
So give him a copy of it. Let him have a look at it. You have a look at it. We'll relist it next week. You take notice.
I have applied annexure according to annexure A.
Let us
serial number 17.
let us see.
Shanpoganalli, Chamanalli, SC candidate.
Let us see.
Annexure A.
You have a look at it. You have a look at it. We'll relist it. ಇದು ಯಾವ್ದಿದು? Relist the matter week after next. You have a look at the Tiddupadi Adna, note bani.
Date
Date.
Yes.
Serial number 41. Regularization matter.
At 2:30, make a mention at 2:30 when I come back. 2:30.
Actually, synopsis.
The dates you ask the court officer. Any adjournment you ask the court officer.
Court officer? Court officer?
ಇಲ್ಲ ಇನ್ನು ಮುಟ್ಟಿದ್ದಾರೆ ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಕೇಳಬೇಕು ಅಜ್ಜನ ಆಯ್ತಾ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ will not be busy. ಜನ ಕಮ್ಮಿ ಅವರೇ ಸರ್ ಅಂತಿದೆ.
ಮೇಡಮ್ ಹೇಳಿ, ಕೇಳ್ತಾ ಇದೆ, ಹೇಳಿ ಮೇಡಮ್. ಮೇಡಮ್ ಹೇಳಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 33.
33 ಹಾಗೆ ಇದೆ, ಅದು ಇದಾಗಿಲ್ಲ ಈಗ, ಅಪ್ ಟು 30 ತನಕ ಆಗಿದೆ. ಮಧ್ಯಾಹ್ನ ಡಿವಿಷನ್ ಬೆಂಚ್ ಮುಗಿದ್ಮೇಲೆ ತಗೊಳ್ತಾರೆ ಮೇಡಮ್.
ಅಲ್ಲ ಇದು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳಕ್ ಹೇಳಿದ್ರಲ್ಲ ಸರ್, ಅದು
ಹೇಳಿದ್ರೆ ಹೌದು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳಕ್ ಹೇಳಿದ್ರು.
ಹಾ.
ನಿಮ್ಗೆ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಬೇಕಲ್ವ, ನೋಡೋಣ ಇನ್ ಕೇಸ್ ರೀಚ್ ಆದಾಗ ನಾನು ಹೇಳ್ತೀನಿ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳಿದ್ರು ಅಂತ ಹೇಳ್ತೀನಿ ನಾನು.
ಅಲ್ರಿ ಇವಾಗ ಕೇಳಿದ್ರೆ ನೀವು ಬರ್ಕೊಳಲ್ವಾ, ಅವರೇ ಕೊಡ್ಬೇಕು.
ನಾನು ಬರ್ಕೊಂಡಿದ್ದೀನಿ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳಿದ್ರು ಅಂತ ಬರ್ಕೊಂಡಿದ್ದೀನಿ.
ಅದೇ ಅನ್ವೆಲ್ ಇದೆ, ನಾನು ಕಾಫ್ ಇದೆ ಅಂತ ಹೇಳಿ ಅದ್ರಲ್ಲಿ.
ಹಾ ಹೇಳ್ತೀನಿ ಮೇಡಮ್, ಹೇಳ್ತೀನಿ.
ನಾವು ಪ್ರೆಸೆಂಟ್ ಇರ್ಬೇಕಾ? ಡಿವಿಷನ್ ಬೆಂಚ್
ಪರವಾಗಿ ಹೇಳ್ತೀನಿ ಬಿಡಿ ಮೇಡಮ್, ಪರವಾಗಿ ನಾನು ಹೇಳ್ತೀನಿ.
ಅಲ್ಲ
ಹೇಳ್ತೀನಿ.
ಕಾಲ್ ಮಾಡ್ತೀರಾ, ಕಾಲ್ ಮಾಡಲ್ವಾ?
ಕಾಲ್ ಮಾಡ್ತೀನಿ, ನಾನು ಕಾಲ್ ಮಾಡಿದಾಗ ನಾನು ಹೇಳ್ತೀನಿ.
ಓಕೆ
ಹಾ ಹೇಳಿ ಮೇಡಮ್.
230 matters ತಗೋತಾರಾ?
230 ಮ್ಯಾಟರ್ಸ್ ತಗೊಳ್ತಾರೆ ಮೇಡಮ್, ತಗೊಳ್ತಾರೆ. ಹೌದು, ಆಫ್ಟರ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ತಗೊಳ್ತಾರೆ.
ಹೌದಾ? ಓಕೆ. ಮತ್ತೆ ಇದು ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರಾ ಸರ್?
ಹೌದು.
ಓಕೆ, ಅದು ಬಿಫೋರ್ 230 matters ಆಫ್ಟರ್ 230 matters? ನಮ್ದು 35 ಇದೆ, ಅದಕ್ಕೆ
ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ, ಆಮೇಲೆ ಹೇಳ್ತೀನಿ.
ಸರಿ ಸರ್.
To the respondent.
Appear for respondent 1 to 13.
Any serious objection in Mr. Jayant appearing for the
Bench. There is death of one of the respondents which is made. The last of respondents.
that would come up once we permit him to appear. Until then, we can't recognize. If we permit him, we can do all these things. If you have any serious objection, it's been argued twice.
Please.
But is there any serious objection?
I have placed my objections on record.
Supreme Court judgments are there which can permit him.
The trust and judgments, but I'm only saying that the party person committee had also rejected his appearance before the court.
Only for the reason that he is the husband and not a party to the proceeding.
Not a party. Then
That's why it's before us.
please, and I had also read out the provisions of the Advocates Act 29 to 33 to show that he will not be entitled to plead and argue the case. He can only make application. That is what I had submitted, and
In light of the Supreme Court decision.
my submission is only this. Wherever Supreme Court has also allowed a particular person who is a power of attorney holder to appear, they have done so only in respect of the proceedings before the Supreme Court. Now, Supreme Court rules itself very clearly provide that a power of attorney can also appear. In view of that, Supreme Court would have taken a very liberal view. But the view taken by the apex court in my number submission cannot be applied to all other courts. Otherwise, any person could come and say, by virtue of the power of attorney, I could appear before this honorable court. Of course, discretion lies with my lords. No second thought on
Husband, not that he is a third party.
Yes.
Because of that fact that he's a husband and emotionally quite connected to this case only, I have objection to the facts that he should not appear. Because if you, my lords may kindly look at the cost item itself, you can see the number of applications filed, which in my humble submission are very, very unnecessary. Even before the trial court he had done so, trying to implement bank managers, where the bank account of the respondent number 1 was held. All those assets were also tried to be brought in. Now, it is difficult to explain the legality of why such an application should not be made in this court.
No, we
My
cannot,
submission will not
we cannot reject an application on the basis of what he may do. We can allow it, then if he does anything like that, then we can recall the order.
Please, I leave it to my lords.
By
Discussion is
imposing
with my lords.
whatever terms, conditions, everything. Mr. Jayant, you are put on notice that if any of those kind of applications are filed, which ought not to be filed, or you conduct the proceedings in a manner which you ought not to conduct, then there could be serious consequences to it. Not only just recalling the order, but there could be financial consequences also.
No, that's a different matter. We are only on the point whether you can be permitted to argue. So if we exercise some discretion in your favor, you put on notice, because we do find that many a time when party in persons are arguing,
should be called
the
to
court
close the matter.
finds it difficult because there are some matters of procedure and practice which party in persons sometimes are not aware. That is a practical difficulty. That is divorce the legal position. So if we do exercise discretion in your favor, you put a notice to be cooperative and try to ensure that the main issue comes rather than complicating it. And the only reason being that if you look at the cause list and the number of notes, sometimes it's a little. So the only point is that we have to get into the core issue rather than getting stuck on all these procedural formalities. Yes, yes.
Reserve it for orders on the application. This is on the main matter. This is on the merits of the matter. First, we have to decide on whether to permit you. There has to be an order passed. Then we'll come to a review. Reserve the application for orders. Third, counsel for the petitioner and respondents on IA number. The separate IA file. IA number. Filed by the party in person seeking permission to represent himself in the matter. So, that the party in person has filed the synopsis of the service thereof on the counsel for the respondent. The same is taken on record.
But my objection for the application.
We'll come to that later. We can't recognize anything that is filed. It will be permitted. We pass orders on. You file your synopsis, everything is filed. We'll pass orders. Earlier, you filed your written submissions. And first, we'll have to decide whether to permit you to be as a party in person or not. If we decide to permit you, then this question would come up. If we decide not to, then you'll have to engage the service of the lawyer. It will be considered thereafter. Once your application, orders on your application is passed, then the review petition will be taken up. You want to take it back? I'll go to that. Yes. You want to file it, you can file it. If you want to take it back, you can take it back. Number 2. We'll pass orders soon. It will be taken. Dishachari, there is a specially constituted bench. One day andre ನೀವು ಇನ್ನೊಂದು ಸತಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡಕ್ ಆಗತ್ತೆ.
Examination
What has happened, Mr.
They are seeking for renewal of the order. Now during presence of this 25/10/2021, review of the order, we are going to work with the final order. According to the information to get the impleadment order.
Writ appeal was against the interim order.
Where there are the landheads, without liberty to possibly call it, I mean, admitted without having affiliation. Paragraph 8 also recorded finding do not have recognition from city, but also application by the college.
What is left to be reviewed, Mr. Jagdish Acharya? The single judge refused the interim order. It came up an appeal as against non-grant. That was dismissed. So you continued the writ petition. No, writ petition is dismissed. So where is the question of considering interim order after the dismissal of the writ petition?
You are now in state.
So the writ petition itself is rejected. What survives in this interlocutory procedure?
Only when I declare the result, that's all. Not by anyone, not sufficient.
That has become infructuous. We can't. We can't pass such orders, and we will never pass such orders. No, it's infructuous. There's nothing. No, how can it survive? No. You have to argue now also. You just tell me how, once the writ petition is disposed of, how can a writ appeal against an interlocutory application survive? That's all your contentions will keep it open, including what you are seeking to be raised in the event you file a writ appeal against this order. We'll keep it open, all your contentions. No, you tell us how it survives. I'm not going to. Not recently, 25th October 21. No, you have a look. Put it. Then we cannot constitute bench like this, sir. No, please have a look at it. No, there is no case, sir. I'll keep everything open in the appeal that you are going to file. No, there's no point in unnecessarily adjourning the matter. Please understand. No. There's nothing to be ready in this. No argument. It has become infructuous. You take that in the writ appeal. Take that in the writ appeal. Put it.
I'm ready to argue.
The review petition has been filed seeking for review of the order dated 3/3/2021, passed in writ appeal 166 of 2020. It is a notice that the writ appeal has been filed, that the review petition has been filed, seeking to review the order whereby no interim order was passed by the learned single judge. Full stop. As against the non-granting of the interim order by the learned single judge, writ appeal was filed, which was dismissed. Full stop. And review is sought of such order of dismissal. It is to be noticed that the review petition eventually relates to an order of the division bench passed as against the interlocutory proceedings in the writ petition. It is brought to the notice of this court that the main writ petition 2790 of 2020 called with 2777 of 2020 has itself been disposed of. Dismissed. By dismissing the writ petitions. Accordingly, nothing survives in the present review petition. However, all contentions advanced are kept open to be raised in any appeal if filed against the order in WP 2790 of 2020 called with 277 of 2020.
You any application representation by me. Later. You are asking me direct. Consider.
University to transfer them to any affiliated college. See, today they have not done so. But if I are also declared interest now, they are not getting a valid certificate.
My previous you are you are I will make application before the authority. Director to consider. Yeah, representation.
That cannot be considered.
ಯಾವ್ದು ಪೆಂಡಿಂಗ್ ಇದೆ ಈ ಆಯ್ತು ಯಾವ್ದು ಪೆಂಡಿಂಗ್ ಇದೆ
Court officer. Court officer, ಇದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ ಮಾರ್ನಿಂಗ್ ನಡೀತಾ ಇದೆ ಬಿಫೋರ್ ಲಂಚ್
2:30 ಮ್ಯಾಟರ್ಸ್ ತಗೋತಾರೆ
2:30 ಮ್ಯಾಟರ್ಸ್ ಓಕೆ
Please unmute total mic. Total mic is muted.
Convenience. But in seal number 72, we are concerned with lots 9 petitioners who are working as assistant engineers lots in the KPTCI. My synopsis, serial number 1. They were appointed lots. They were appointed lots on 5/11/2003 on a contract basis as regards lots sanction course. These appointments lots made not just in respect to these petitioners, but a number of batches lots relating to the KPTCL. And though they were made lots on a contract basis, they were made lots not only against regular posts, but way lots procedure for appointment of regular employees, that is through lots open competition by inviting advertisements on the basis of inter se merit and following the roster for reservation. Page 21 shows lots the employment notification issue pursuant to which lots these
appointments were made. And at page 29, your lordships find a minutes of meeting of the board of directors of the KPTCL in 2007, which seeks to explain the reason why they were not recruited directly but appointed on contract. Please come to page 30, subject 59 of 2008. Appointing and regularization of the services of contract assistant engineers.
Page?
30 minutes.
Yes.
Petition.
Yes.
This is part of the minutes of meeting. Subject is 59 of 2008. The board was apprised as follows. In order to overcome severe shortage of staff at the cutting edge level, 830, not just my mark this, 830 assistant engineers and 385 contract junior engineers were recruited during 2003-2004 in KPTCL ESCOMs for a period of 1 year, extendable up to 3 years on a consolidated monthly remuneration of rupees 8,000 and 5,000, respectively, against employment notification number so and so, dated 7/5/2003. Please mark this notes duly following due recruitment process and reservation policies of the government. They were not recruited directly in order to have candidates who are willing to work in the field with sincerity and dedication. This is the reason for not having appointed them on a regular basis at the first instance, so that they would work with sincerity and dedication. Then, Lords, the contract of these engineers has been renewed from time to time, and they are working in KPTCL bar ESCOM. Their work has been very satisfactory in most cases. They have been working well. Board finds that they are having good talent and experience of working in the field. Now it is not desirable to dispense with their services. Since the above contract engineers are working for more than 3 years, and in order to make the above engineers more accountable and to entrust additional various responsibilities of the regular post of AEs, it is proposed to appoint them on a permanent basis with prospective effect. KPTCL has scrupulously observed all the conditions of appointments prescribed under the KAB regulations, vis-a-vis qualification age, cutoff, marks, etc., even though the appointments were on contract basis. Further, they have been appointed through a transparent selection process involving calling of applications through newspaper advertisements, conducting a special technical aptitude test, and considering their academic marks. Government guidelines on reservation and recruitment have been followed scrupulously by the KPTCL. Board was also apprised of the need to avail their services in areas of respective ESCOMs where they are working even after their appointment. And accordingly, my lords, the resolution was passed at the bottom of the page. Resolved that approval be and is hereby accorded for appointment of the contract AEs and contract JEs recruited on contract basis against employment notification so and so on a permanent basis, subject to the following terms and conditions. And it is pursuant to this minutes and resolution that, my lords, the various batches came to be regularized. Some of them, my lords, had to move this honorable court for the purpose of regularization, including the petitioners herein. Some were appointed on their own. But the fact is that, my lords, as many as 2,817 contract engineers were regularized. I place before your lordships with the synopsis a table, my lords, with the details of these appointments. Your lordships, please come to the last page, my lords, the table with the synopsis. Serial number 1, lords, is where the petitioners fall. This is the 2003 batch. Date of recruitment notification, your lordships have seen, is 7/5/2003. Their date of appointment is 5/11/2003. Number of AEs is 830, which includes these 9. Then, my lords, 385 JEs. Total is 1215. And the date for resolution is 16/3/2007 that I read. I hope your lordships have the table. Please.
Just one. Yes.
Please. Serial number 5 is the date of the resolution that I read to your lordships, page 30, 16/3/2007. The date of actual regularization is 30/4/2007. And the last column, duration between the date of appointment and absorption is 3 years and 5 months. Similarly, my lords, we have given your lordships the details of the other batches. 2005 batch, appointment in 2006, but regularization in August 2007. So the duration is just 1 year and 2 months. The third batch, which is 2006 batch, regularization in 2007, the duration that they worked as contract employees is merely 10 months. And finally, my lords, the 2007 batch, regularized in 2010, but regularized retrospectively pursuant to directions of this honorable court by an order dated 16/12/2015. This is only to say that batches, my lords, that were appointed against regular vacancies pursuant to an advertisement issued had to endure different periods of delay before their regularization could take place. But the fact is that as of 30/4/2007, my lords, they stood regularized. And their original recruitment was 7/5/2003.
The regularization was with effect from or prospective or what?
Lords, in the resolution, they say that it would be prospective. I will take my lords to the order of regularization.
But what is the issue involved?
Issue is, my lords, that 30/4/2007 is my regularization. There was earlier, my lords, a pension scheme in force, which applied to us, no doubt, in 2003, even as of 30/4/2007. In the interim, a new pension scheme was introduced by KPTCL, which, my lords, provided for a contributory pension. Now, that scheme, A, could not apply to us because it became effective after our regularization. Secondly, that scheme is made applicable to what they call new entrants, which according to us, my lords, petitioners can never be regarded as new entrants because we were originally appointed in 2003 and appointed by the KPTCL against regular vacancies for a reason that they assigned in the resolution, because they felt we will work with more sincerity if we are on contract basis. But by the impugned order, KPTCL has refused to give us the benefit of the old pension scheme, holding that since we were regularized not on 30/4/2007, we are to be treated as new entrants and therefore covered by the new pension scheme. That is the short point before your lordships.
The order of regularization, anything is indicated regarding with effect the service?
May I take your lordships to the order, lords? Page 29, sorry. Order is at 27. 30/4/2007.
Page
7. This is an illustrative order.
Yes.
Please see the subject notes, appointment to the post of AE. Reference is to the employment notification of 2003. So it's not a fresh appointment. Reference 2 is the decision of the Board of Directors of KPTCL, meeting held on 16/3/2007, Annexure C. You were appointed as AEs on contract basis against notification dated 7/5/2003 and working in so and so. Considering your service as contract AE, KPTCL is pleased to appoint you on a permanent basis in the time scale of so and so, with effect from the date of this appointment order, on the terms and conditions detailed in the enclosed annexure. Your appointment will be against the post in which you are presently working on as is where is basis. I can skip that. 2. Your service on contract basis shall not count for any purpose, including fixing salary, seniority, promotion, or pension. And we do not also claim that period for the purpose of seniority limits. I am instructed to make that sufficient. Then your seniority on permanent appointment to the post of AE will be fixed provisionally below the last permanent AE working in KPTCL. And the rest of the provisions, my lords, please see 5. You are not entitled to pension as per the existing pension rules. However, you will be covered under the contributory pension scheme, which is under consideration. Kindly mark this. Under consideration for adoption by KPTCL with effect from 1/4/2006. So they, by this condition 5, seek to deny me the benefit of the pension as per the existing pension rules on the basis that we will be covered by a contributory pension scheme which is not yet even in force. And then the other conditions, my lords, may not be germane for the purpose of this dispute. I will take your lordships now.
What happened to that,
They issued a notification.
that contribution?
Yes, they issued a notification. I take your lordships now to page 40. It was pursuant to a central government notification dated 22/12/2003 that was enforced not for central government employees. Lordships get that at page 33 of the petition. This is of course not inapplicable to us. It is only for central government employees. But this was the basis of the KPTCL making its decision, which is, my lords, at page 40, annexure D2. KPTCL implementation of new defined contributory pension scheme with effect from 1/4/2006 for new entrants.
This is the one that they were referred to in the clause 5.
Please. But it was not enforced then. This is made applicable from 1/4/2006, no doubt. And that will be one of the questions before your lordships, whether retrospectively the benefit of a more favorable pension scheme could be taken away. And that is covered, my lords, by judgments. That a vested right of pension cannot be abridged retrospectively. But it is curious that in clause 5, they say on 30/4/2007 that I will be governed by a scheme which is under consideration. And it actually came to be notified, and this date would be crucial, my lords. It actually came to be notified or resolved on 5/7/2007, page 40, which is after the date of my appointment.
Your date is April, is it?
30/4/2007. And working, my lords, from 5/11/2003.
But between the dates of your appointment
Yes.
till the date of regularization, apart from the emoluments that you were getting, are no other benefits.
No other. Lord, just see this order at page 40, which is the basis of their rejecting us when we sought the benefit of the old scheme. They refer to the various memorandum of settlement, etc. Then, my lords, order number so and so dated 5/7/2007. KPTCL is pleased to accord approval for implementing new defined contributory pension scheme with effect from 1/4/2006. Please mark this, lords, for new entrants. New entrants to KPTCL bar ESCOM service as follows. The new defined contributory pension scheme shall be mandatory to all new recruits to KPTCL service joining on or after 1/4/2006. The monthly contribution shall be 10% of the basic pay and dearness allowance thereon to be paid by the employee and matched by KPTCL in equal proportion. However, there shall be no contribution from KPTCL in respect of individuals who are not part of KPTCL ESCOM employees. then contributions have been so and so returned. Lords, 3 can be skipped. Lordships may only mark in this 6 and 7. The effective date for operationalizing of the new pensions system shall be from 1st April 2006, and 7, the existing provisions of defined benefit pension shall not be available to the new recruits joining bar already joined service on or after 1/4/2006. And it is on this basis, my lords, after multiple representations made by us, the APTCL passed the impugned order, which will close, my lords, the facts for this case, which is at page 105. This is, please, dated, lords, 30th January 2016, which is the order impugned before your lordships. Subject is considering the A's and J's recruited on contract basis before 1/4/2006 under old pension scheme, letter dated so and so. With reference to the above, notes, I'll skip that, take your lordships directly to the relevant portion. Please come to page 106. The 4th unnumbered paragraph. However, the concerned have been appointed on a monthly consolidated pay on contract basis and not on permanent basis. And since the concerned have been made permanent with effect from 30/4/2007, hence the new pension scheme applies to the concerned. During the process of regularization, the concerned A's and J's following terms and conditions were issued. They extract that condition. Then, my lords, service conditions. The appointment and continuance shall be subject to the regulations that may not be relevant. Then at 107, the A's and J's who were working on contract basis were regularized on 30/4/2007 and reported to duties based on the conditions specified in the recruitment order. Approximately 8 years later, they seek for the applicability of old pension scheme. The services of the A's and J's recruited in 2003 on contract basis were regularized from the date of 30/4/2007 and inducted into the corporation on permanent basis from 30/4/2007 only. Therefore, they are applicable for new contributory pension scheme. Further, I state that as per the conditions of the corporation, there is no provision for old pension scheme to the A's and J's recruited on contract basis in the year 2003. And they simply, my lords, reject our request for representation on the ground that since the date of regularization was 30/4/2007, they cannot be regarded, they are, my lords, disentitled to the benefit of the old scheme. And they are practically speaking new entrants. Now, lords, our contentions before your lordships are 3 or 4. One is, my lords, that the appointment of these petitioners having taken place in 2003 against sanctioned posts cannot be disregarded while considering their entitlement to pension. This is not, my lords, an additional emolument that they are seeking. The right to receive pension vests in them, my lords, at the time of their appointment. And their non-appointment on a regular basis was not for any fault of their own. It was for a peculiar reason given by the KPTCL that they would be more hardworking and sincere, etc. They were sought to be regularized by the KPTCL, who did it in an ad hoc fashion. Your lordship saw from the chart, some cases they did it in 10 months, some they did it, my lords, in our cases, the longest, as much as 3 to 4 years delay. And that delay cannot, my lords, then become the basis for the KPTCL to take advantage of its own wrong to deny, my lords, the benefit of pension to these petitioners. Thirdly, my lords, They are not new entrants, and I will place case law before your lordships within the meaning of the KPTCL order, and therefore are entitled to the old scheme. And lastly, the retrospective applicability of this order itself, lords, will fall foul of the law because it has the effect of abridging a vested right in the petitioners, lords, to receive pension in terms of the old pension scheme. These are the fourfold submissions, lord, that I will be making in this petition. Lords, we have prepared, my lords, for your lordships, a compilation of case law. I may not refer to all of them. Please first take Lord's Uma Devi, which is at serial number 7 at page 72. Though, my lords, this judgment is oft cited, I wanted to just read one paragraph. Please take, my lords, para 3 of this judgment at page 88, 72 at 88. Para 3 months. A sovereign government, considering the economic situation in the country and the work to be got done, is not precluded from making temporary appointments or engaging workers on daily wages. Going by a law newly enacted by the NREGA, the object is to give employment to at least one member of a family for 100 days in a year on paying wages as fixed under that act. But a regular process of recruitment or appointment has to be resorted to when regular vacancies in posts at a particular point of time are to be filled up, and the filling up of those vacancies cannot be done in a haphazard manner or based on patronage or other considerations. Regular appointments must be the rule. Then in para 4, they set out notes how this rule is sometimes breached. And then, lords, I take a lordship to para 6. The power of a state as an employer is more limited than that of a private employer, inasmuch as it is subjected to constitutional limitations and cannot be exercised arbitrarily. Article 309 of the Constitution gives the government the power to frame rules for the purpose of laying down the conditions of service and recruitment of persons to be appointed to public services and posts in connection with the affairs of the Union or of any states. That article contemplates the drawing up of a procedure and rules to regulate the recruitment and regulate the service conditions of appointees appointed to public posts. It is well acknowledged that because of this, the entire process of recruitment for services is controlled by detailed procedures which specify the necessary qualification, mode of appointment, etc. If rules have been made under 309, then the government can make appointments only in accordance with the rules. The state is meant to be a model employer. Employment Exchanges Act was enacted to ensure equal opportunity for employment seekers. Though this act may not oblige an employer to employ only those persons who have been sponsored by employment exchanges, it places an obligation on the employer to notify the vacancies that may arise in the various departments and for filling up of those vacancies based on a procedure. Normally, statutory rules are framed under the authority of law governing employment. It is recognized that no government order, notification, or circular can be substituted for the statutory rules framed under the authority of law. This is because following any other course would be disastrous inasmuch as it will deprive the security of tenure and the right of equality conferred on civil servants under the constitutional scheme. It may even amount to negating the accepted service jurisprudence. Therefore, when statutory rules are framed under 309 of the Constitution, which are exhaustive, the only fair means to adopt
is to make appointments based on the rules so framed. Lords, it was this jurisprudence in paras 3 and 6 that ultimately led to the Supreme Court, Lords, in Uma Devi to issue appropriate directions, as your Lordships are fully aware, as it regards regularization, Lords, of contract employees, such as the petitioners before your Lordships. It is not that they volunteered, Lords, or asked to be appointed on a contract basis, but in fact were done so by the KPTCL at the risk and cost of, Lords, the equality and the benefits of the service conditions that would be otherwise available to them. Why I cite this is to say, my Lord, that we ought to keep in consideration the fact that their original appointment, though on contract basis, was in 2003. Again, I say, my Lords, I do not claim that period for the purpose of seniority. I accept the condition in the appointment that that period will not count for the purpose of seniority. But my entitlement to pension, my Lords, has already accrued, and that could not be taken away. Now, my Lords, with this in the background, I take your Lordships to a judgment of the Madras High Court with, in almost identical circumstances, the question of who a new entrant is was considered. And in our respectful submission, Lord, this judgment covers the question. This is at serial number 2, Union of India versus Punya Koti.
Just one question. Now, the regularization order makes some reference stating that this will not be counted for certain purposes, including pension. Now, but you are saying that you are right for pension. It took birth on the very date you were appointed at the first instance.
Please, that's my case.
Yes.
Please. What's page 16?
Page
1/6, Lords, of the case compilation. A division bench judgment of the Madras High Court. Please come to para 16. I can tell your Lordships that this was also a case relating to the interplay, Lords, between the old pension and the new pension scheme, as is borne out from the facts in para 1 itself, Lords, where the Union of India challenged the orders of the CIT. Lords, just see the third line, so the factual matrix is clear before the Honorable Court. The fourth line, the said OA was filed by the respondents praying for a direction to extend the benefit of pension under the old pension scheme, as they were granted temporary status with effect from 31/12/99 on condition that 50% of their service rendered under temporary status would be counted for the purpose of retirement basis after their superannuation and after entering 3 years of continuous service after conferment of temporary status. The casual laborers would be treated on par with temporary Group B employees for the purpose of contribution to the General Provident Fund. The OA was allowed by the CAT by following the judgment of the principal bench in so and so. It is against this that, Lord, the union came before the High Court. Now, Lords, the contention at para 7 is what led to the adjudication. The Learned Counsel appearing for private respondents, on the other hand, submitted that private respondents' initial date of appointment in whatever capacity should be taken as the date of appointment in IGCAR. And they were also granted temporary status from 31/12/99 with a specific direction to count 50% of the temporary service for the purpose of pension and other benefits due to want of vacancies in Group D post. Their absorption in permanent Group D post was delayed, as is the case here. And the new pension scheme, which came into effect from 1/1/2004, cannot be applied to persons who were already in service either as casual laborers or on temporary basis. The new pension scheme only states that persons appointed on or after 1/1/04 are governed under the new pension scheme. The private respondents, having been appointed long ago as casual labor, were granted temporary status from 31/12/99, cannot be treated as fresh appointees appointed on or after 1/1/2004. And therefore, the CAT was justified in allowing the OA by following the order passed.
Para 8 lords. We have considered the rival submissions of the council. 9. The only issue that arises for consideration in this writ is whether the new pension scheme which came into force from 1/1/2004 is applicable to persons who are already in employment, either on daily wages or as temporary employees, and whether they are entitled to get pension under the CCS pension rules on being absorbed in permanent establishment after 1/1. They were absorbed permanently after 1/1/2004. It is not in dispute that the private respondents herein were appointed as casual laborers on daily wage basis for cleaning and assisting the technicians and scientists carrying out the task in various labs of IGCAR. Government of India has introduced a scheme called Casual Laborers So-and-so scheme with effect from 1/9/93. According to the said scheme, the casual laborers employed as on the date of the order, that was as on 1/9/93, who have rendered 1 year of continuous service in IGCAR, are bound to be conferred temporary employee status, and they are to be regularly selected under Group B after selection for permanent absorption. It is not in dispute that casual laborers were engaged. That sets out the fact of their absorption. And then I take your lordships, because the rest of it sets out the details of how they were absorbed. Paragraph 15, Rule 14 of the CCS pension rules stipulates conditions which, subject to qualifying service for pension, can be concluded. Under 14.2, it is stated that employees paid from contingencies are employed in types of work requiring full-time workers. I'll skip that also, my lordships. Convenience, the bottom part of 15. Thus, it is clear that persons appointed as contingent staff either on temporary basis or on daily wage basis, who serve not as part-timer and receive salary every month, are entitled to count 50% of their service for pension on the regularization for absorption regular establishment. The new pension scheme, which is called contributory pension scheme, came into force from 1/1/2004, and the same is applicable to all new entrants of central government service as per the scheme. And the respondents 1 to 16 cannot be treated as new entrants in the central government service IGCAR. The word new entrant, please mark this note, the word new entrant has got a definite meaning. That is a person who enters recently, a person already in service, either as contingent staff or temporary staff continuously and absorbed in permanent establishment on or after 1/1/2004, cannot be termed as a new entrant into service. The new pension scheme can be applied only to persons, please mark this note, appointed for the first time as casual or temporary or permanent employees on or after 1/1/2004.
There's a slight difference insofar as in your order of regularization, this 50% is absent.
Is missing. I'm conscious of that.
Whether in that context they are saying that their appointment could be dated back because pension 50% even during the time before they regularize.
But we horse that the Madras High Court was considering an identical condition, which is as to who a new entrant is. And in fact, that is the ratio that, Lords, I very respectfully place before your Lordships. The ratio or the interpretation of the concept of a new entrant for the purpose of pension. I bow down, my lords, on facts that distinction is certainly there. But applying this principle, whether, my lord, somebody who has been in service from 2003 could still be regarded as a new entrant is the question. And that has categorically been held, my lords, in para 16, that it can only be a person who enters on or after the cutoff date, be it as a casual, temporary, or a permanent employee. Whereas the undisputed position in the given case is that we were working from 2003. And the order of the KPTCL, lords, really.
Which is this cutoff date of 1/1/2004?
That in the Madras order, lords. Yes, that is. Para 3, lords, sets it out.
Yes. Yes.
The notes continuing to read at para 17. Similar issue was considered by one of us in WP so and so. In the said case, the order of the government of Tamil Nadu, dated so and so, introducing new pension scheme with effect from 1/4/2003, came up for consideration. It was held that persons appointed or recruited after 1/4/2003 are not governed under the Tamil Nadu pension rules, and the persons appointed prior to the said date, even in consolidated salary or whose appointments as secondary grade teachers were approved subsequently with time scale pay after passing child psychology training, whose earlier services were ordered to be counted by the division bench of this court. In the said case, the teachers were not paid salary before passing of this child psychology training, and they were ordered to be treated under the Tamil Nadu pension rules as their initial appointment was prior to 1/4/2003, and the said order was implemented. This also refers not to other orders of the Madras High Court. I may skip to my lords. Para 21. Similar issue regarding fixing of pension by adding dearness pay by giving cutoff date was held arbitrary and violative of Articles 14 and 16 of the Constitution by the Supreme Court in the decision reported in so and so. The discriminatory treatment meted out to retired persons while granting pension was not approved by the Honorable Supreme Court in the well-known case of Nakara versus Union of India. The right of government servants to receive pension is not a bounty, and it is a statutory right conferred under the pension rules applicable from the date, please mark this, lords, when the government servant was appointed either on daily wage, temporary or permanent basis. Permanent absorption having been ordered considering the temporary service rendered earlier under any stretch of imagination, the persons who are already in employment prior to 1/1/2004 cannot be treated as fresh appointees for the purpose of applying the new pension scheme, which came into force from 1/1/2004. The Supreme Court, in the decision reported in State of Jharkhand versus Srivastava, has held that the right to receive pension, gratuity, or leave encashment can be treated as a right to property in terms of Article 300A of the Constitution of India. If a person eligible to get pensionary benefit on retirement, if denied by giving a narrow interpretation of the rules, it will definitely be in violation of Article 300A of the Constitution. In fact, I did not make this point, but I see that para 23 gives an additional ground to the petitioners, which is a violation of 300A if such an interpretation is to be taken by the KPTC. Considering the overall aspects of the matter, as well as the undisputed fact that the respondents have been appointed as casual laborers and subsequently conferred temporary status from 31/12/99, merely because they've been absorbed permanently in the year 2005 in Group D, they cannot be denied of their statutory right. The tribunal has approached the issue in a proper perspective, and we confirm the finding. In fact, notes on this fact, this judgment, the facts were slightly more difficult for the employees because their regularization itself came in 2005, lords, after the cutoff date. Whereas your lordships have noticed in our case, there is a nuance on the facts, which is that we were, even if we take the date of regularization for the sake of argument, that too was prior to the date of the order issued by the KPTC. 34/2007 was the date of our regularization, and the order came to be issued on 5/7/2007. So on that factual aspect, the petitioners before your lordships are in fact a little better placed.
5/7/2007 is the
government order, the KPTCL order, lords, adopting the new pension scheme.
The new pension scheme became available only after this 5/7/2007.
Yes, lords, though they made it retrospective. They made it effective from 1/4/2006.
You are saying technically, as on the date of the order of regularization, you are right, cannot be with respect to something that came later.
Please. And it's curious, lords. In fact, it becomes the facts of this case, a case of lords, lordships could even see it as mala fide action because they want to apply a scheme which they have not yet adopted. It's very rare to see a condition which says you will be governed by a scheme which is under consideration. If it was not yet finalized and notified or ordered by the KPTCL, the question of making it applicable, my lords, itself is an arbitrary action. But be that as it may, the right crystallized, my lords, in 2003, and at any rate, on, my lords, the date of our regularization, which is 34/2007, admittedly, my lords, prior to this order bringing into force the new pension scheme. I will quickly move on, my lords, to
The regularization order,
lordships.
is there anything that would be counted for that you could refer back to the period prior to the date of regularization, or that is a clean slate?
Lords, it refers to the
For other purposes, though they have got some clause stating it won't be used for seniority, etc. But can it be referred? Has it been referred for any other benefit or no?
But in terms of benefit, there is no reference to any, there is no benefit in terms of the pay fixation or the seniority. But admittedly, my lords, the regularization order refers to the employment notification of 2000. It is not in that sense de novo. Its very basis is the employment notification of 2003, read with the decision of the Board of Directors of 2007, where they recognized the reason for us having not been regularly appointed. To that extent, yes, but otherwise, my lords, to answer your lordship's question directly, there is no benefit as such that is bestowed under this order. And I don't claim it also. To that extent, in terms of seniority, this is, my lords, the desperate position of persons who have to run pilot posts to be regularized. When they are given regularization, they are given in this manner, and they take it. And it may be difficult then to once over argue, my lords, that seniority has to be retrospective. They could, my lords, if your lordships ask me academically, not in this case. Petitioners would certainly be entitled in principle, basis Uma Devi and others, to say that if you have chosen conveniently to appoint me on a contract basis, then why should my seniority be denied? I think, lords, maybe in a different case, that question could certainly be argued, keeping in view.
The case of employees who died without their services being regularized, and the question that came up is whether they were eligible for compassionate appointment. There is a government order that is passed stating that if for delay, not having that has nothing to do with the employee, and no order was passed and it was pending, then notional regularization be made on their completion of 10 years and their application be considered.
Where an equitable manner in which rights are protected. I will not do some research and pull out that order also. But returning to the compilation, our respectful submission is this: Madras judgment, not the division bench judgment, directly governs the interpretation of who is a new entrant. It has been followed, my lords. I will just point to your lordships the orders where this case has been followed. One is, my lords, at page 29. A single judge of the Madras High Court. I will just show your lordships. At para 5. Para 3 sets out the facts. It is not in dispute that the petitioners were appointed on contract basis and their services were regularized after the introduction of the new pension scheme. However, it is contended that since they had entered their services prior to 1/4/2003, petitioners would claim that they should be brought under the old pension scheme and not the new pension scheme. Question as to placing petitioners in the old pension scheme is no longer res integra. Then, Lord, the judgment in Punyakoti is referred. And para 6 is not in dispute that all the petitioners
are entered their services on contract basis prior to the introduction of the new pension scheme. Therefore, they will necessarily have to be brought under the old pension scheme. And accordingly, the direction by way of mandamus was issued. Notes. At page 42 is one other judgment of a division bench of the Madras High Court, which considered interpretation of the phrase newly recruited. Kindly come to para 9 at page 46. Para 9. The pension papers of the first respondent were returned on the premise that there is a bar in considering the claim for pension in terms of so and so. The learned single judge, after considering the relevant GOs, has clearly held that the government orders are in relation to contributory pension scheme applicable to newly appointed employees after 1/4/2003. The respondent having been appointed in the year 1980 and regularized on 23/6/2006, 26 years later, would not fall within the parameters of newly appointed employees after 1/4/2003. The GO cannot be made applicable to the respondent, as rightly found by the learned single judge, as the new scheme applicable to newly appointed employees on or after 1/4/2003. The appointment of the respondent is not a new recruitment, and it is a case of regularization after putting 30 years of service. In this regard, it is relevant to extract paras 7 and 8 of the order of the learned single judge. When the very GO says that the new pension scheme, namely contributory pension scheme, is applicable to persons who are newly recruited after 1/4/2003, I fail to understand as to how the respondents are entitled to treat the petitioner as a newly recruited person after 1/4/2003, merely because his service was regularized on 23/6/2006. Respondents are not disputing the fact that the petitioner was originally appointed as water supply attendant as early as 27/2/1980. Certainly, the words newly recruited cannot be construed to mean that it applies only to persons whose services were regularized before 1/4/2003. Please mark this, Lords. New recruitment and regularization are two different aspects and stages, and therefore the respondents are not entitled to put both together in the same boat and deny the benefit of pension under the general scheme to the petitioner. Accordingly, Lords, at para 10, the order of the learned single judge was confirmed. And in a way, this, though it does not say so, it, Lords, extrapolates the doctrine of estoppel, that the employer is estopped from contending that you are only a new entrant, as if Lords, he or she was invisible before 2007, when it was you who chose to keep me as a subordinate contract employee for convenient reasons and took your own sweet time to regularize. All of that material is conveniently given a go by. And that is where, my lords, their appointment order becomes crucial. Because it is not as if it is as your lordship said, a clean slate in that sense. It clearly is relatable to the original notification. They are conscious of it. It is an exercise of regularization. But I think I
want you to draw a parallel.
Not just.
Just to test your argument.
Please.
That suppose you were to challenge the order of regularization and demand that despite the terms of the order, you are entitled to be to take benefits from the date of the first engagement.
Please.
How would it be answered by the court that you place on your next?
I'll
continue. So just look at it that you seek to challenge that order of regularization.
Please.
And then claim that irrespective of the terms of it, in law you are entitled to be treated from the earlier. What would be the answer?
Because Uma Devi has been followed in different circumstances. I will place that.
Now there are two parts in your argument. One, if you take technically, it's in April and this is in July. One part of it. So the other fallback argument is on a larger issue that it should date back, and your right of pension
Yes.
cannot be interpreted technically, but must be taken from. But apart from that, you are saying the dates, there's a lapse of 3-4 months, and the vested right is as on the date of the regularization order.
And my lords, the order issued by them in any case is applicable to new entrants. The KPTCL cannot in its convenience utilize my services from 2003 to 2007 and in the same breath say I am a new entrant. A new entrant, as the Madras High Court has regularly held in a series of judgments, is somebody who is literally and actually new to your service. Meaning he or she was not in your service, be it in a temporary or a permanent capacity till that date. So really this order only applies to those persons who actually came to the KPTCL after this cutoff date. They may be on contract, they may be permanent, that's a separate issue. But the phrase new entrants, by no stretch of fair imagination, unfairly of course, it can be done, but by a fair imagination, it can in no way extend to those who have been in your service from 2003.
But what is the effect of that clause which says that with effect from so and so pension in the date of your regularization, I mean appointment?
That is for fixing. The word used there is for fixing salary, seniority, promotion, or pension.
No, they say they refer to the pension, isn't it? Pension.
Yes.
Which is that page?
27. I read it once. I think my friend is referring to clause 1. I'll read it. 5. You are not entitled to pension. That I read your lordship. You are not entitled to pension as per the existing pension rules. However, you will be covered under the.
So what is your how do you get across this clause?
This is non-est. This clause is non-est because an employer cannot say to me that you will not be entitled to pension as per the existing rules, but you will be only entitled or covered by a scheme which is prospectively in consideration. It is a non-est condition because it deals with or refers to a scheme which is not even in force. Had this scheme been in force, my lords, there would be perhaps some elbow room for debate or discussion as to which of the schemes may apply. But this is a clause which is ab initio void. KPTCL as a responsible employer cannot, my lord, say to a regularized employee that you will never get pension. Such a clause your lordships will strike down in a moment. What they are saying here is, we are considering some fresh scheme. As and when that comes, that will apply. Now, that sort of condition, lords, is unknown to an employment order. It can only refer to a condition or a scheme or a rule which is in force. And which is in force on the date of the order. And my lords, in any case, the order issued by them at page 40 will have to, my lords, govern the field. Regardless of what is said in this clause 5. Ultimately, my lords, the order issued by them, this is an order in rem. It is not an order only for these petitions. The order at page 40 will, my lords, apply in its own terms. So the condition there lapses or becomes irrelevant in light of the order issue. And your lordships have seen the order at page 40. It refers to new entrants with effect from 1/4/2006.
Even otherwise, just see if there is something, some authority on these employment contracts and clauses to the clauses introduced, which may be deemed to be unfair.
Please note, I am grateful to your lordship. There are judgments on that point. I will place. Just to return to the case compilation with your lordship's leave. But these are the line of judgments on the interpretation of new entrant. There is also one other dimension, which is whether the benefit, my lords, of the scheme bear with me for a moment. Whether this could be, my lords, given retrospective effect at all. Is a judgment, my lords, in Ajay Kumar, which is serial number 1 of my compilation.
Retrospective effect to April or to April, that's what.
April, because they say 1/4/2006 here. But my lords, April of 2006, my regularization was April of 2007. In this GO, they say it will apply with effect from 1/4/2006 for new entrants, with effect from 1. Whether that vested right to receive pension under the old scheme could be, my lords, diluted by retrospective. My lords, the division bench judgment of the Delhi High Court, Justice Sikri's judgment, is come to para 3, which sets out the impugned OM therein.
Just one.
Please.
Yes.
Please.
How much time will take roughly?
This may be another 15 minutes.
Yes.
May I continue?
Yes.
Great. Para 3, lords, at page 5. However, the DOPT issued another OM dated 26/4/2004, which pertains to the introduction of the new pension scheme, modification of scheme for grant of temporary status. Operative portion of the scheme is as under. 1, lords. As the new pension scheme is based on defined contribution, the length of qualifying service for the purpose of retirement benefits has lost its relevance. No credit of casual service as specified in para 5 shall be available to the casual laborers on regularization under Group D, post on or after 1/1/2004. Now, my lords, this was considered at para 5. Thus, though it is not disputed that the government could come out with such a scheme as contained in OM so and so, in the opinion of the tribunal, it could not be applied retrospectively in respect of those employees, like the respondents, who had been conferred the temporary status and were contributing towards GPF for the last number of years. We may note that in other OAs decided by the tribunal, the same view is taken. We may point out at the outset that on earlier occasion also, an identical judgment was rendered by the tribunal in so and so. Against that judgment, Union of India had filed a writ petition. However, the said writ petition was dismissed by a division bench of this court by judgment dated so and so, accepting the reasoning given by the tribunal that the OM dated 26/4/2004 could not be applied retrospectively. In the short order dated so and so, while dismissing the writ petition filed by the Union in limine, this court observed as under. In our view, a right has vested, please mark this, notes, in the respondents by virtue of their regularization on 31st March 2004 and a modification on 26/4/2004 cannot apply retrospectively, particularly when the said modification does not say specifically that it will apply retrospectively. It only modifies the existing scheme and has to be understood to operate in future and not retrospectively. Accordingly, the CAT has rightly held the modification will not apply. Then, lords, it would be necessary to point out at this stage that against the order passed by the CAT Jaipur, which is noted in the improved order, also writ was filed. I'll skip that. Take your lordship straight away to para 7, where Uma Devi is concerned. Learned counsels for the petitioner tried to contend that the view taken by this court is not proper. Attempt was to persuade us to refer the matter to the full bench. It was primarily argued that there was no entitlement to regularization as decided by the Constitutional Bench of the Supreme Court in Uma Devi. Respondents had not become the members of service so far. Benefit of temporary status was given by one scheme by issuing administrative orders, and such administrative orders could always be superseded by other orders, more so when no right had accrued in favor of the respondents. We are not convinced with this argument. No doubt there is no right of regularization in favor of the respondents. However, by virtue of the scheme of 93, the respondents have been conferred with the temporary status. They have therefore acquired a particular status, please mark this, lords, and certain benefits which flow from that status, namely regular pay scale and other benefits like HRA, CCA, holidays, leave, etc. By virtue of the said temporary status, they also started contributing towards the general provident fund. Therefore, vested right accrued in their favor. No doubt it was by way of administrative directions in the form of the scheme of 93, and the government has the right to substitute or modify or revoke those directions by coming out with another scheme, which is done by the OM dated so and so. However, that may apply only prospectively and would not take away the vested right of those who are already enjoying the benefit under the old scheme. We therefore are not inclined to take a different view than that was taken by the earlier bench as well as the Rajasthan High Court. At para 8, the Jaipur CAT order, my lords, is referred, where the tribunal opined at the center of that page, my lords, that by giving temporary status, these employees were elevated to the status of temporary employees, and even the CCS rules became applicable to them. And accordingly, my lords, the writs were dismissed. This judgment, my lords, in Ajay Kumar has been followed by several orders of this honorable court. It is, my lords, really the alternative limb of my argument that in any case, this order cannot be applied retrospectively. But in my writ petition itself, I have annexed, lords, some of those orders. Kindly first come to page 45. This is, my lords, a division bench judgment. At page 54, this order in Ajay Kumar is referred to. If your lordship would like to see the question, my lords, that is at page 70, page 46, the pensionary benefit issue, as is the case before your lordships. Page 46. Petitioners are aggrieved by the order passed by the CAT. By the impugned order, the learned tribunal has allowed the OA filed by the respondent, Mr. So-and-so, and has directed the petitioners to treat the respondent as entitled to pensionary benefits.
You're reading at page
46, minutes of, I'm sorry, of the writ. So sorry.
I'm a little slow.
My lapse, not making that clear.
Yes.
Please, I'm so grateful. Page 45, notes. A writ filed by the union challenging the order of the CAT. The issue is at page 46. Petitioners are aggrieved by the order dated so-and-so passed by the CAT Bangalore. By the impugned order, the learned tribunal has allowed the OA filed by the respondent and has directed, my lords, the petitioners to treat the respondent as entitled to the pensionary benefit under the old pensionary rules from the date when he was granted the casual labor temporary status to discontinue recovery of contribution under the new scheme. Recovery, not even this is the case of recovery under the new scheme, and to refund the recovery so far, if any, towards pension. So an identical issue. This honorable court refers to Ajay Kumar's case, which I read to your lordships in the Delhi High Court. Please come to Page 52, para 8. Secondly, the issue para 8. Secondly, the issue whether such persons would be considered under the old pensionary scheme or the new one is no more res integram. And the same issue had arisen before the CAT Jaipur and the CAT Mumbai, and even in the case of Union of India versus Ajay Kumar. The scheme in these cases was similar to the present scheme. After taking a holistic view of the decisions of the learned Tribunal Jaipur bench, the Tribunal Mumbai bench, and the decision of the Honorable Rajasthan High Court, their lordships of the Delhi High Court were of the opinion that those employees who had been granted temporary status prior to coming into force of the new pensionary rules, those employees were given the benefit of General Provident Fund under the old pensionary rules. Those employees who had also been given the benefit of having their period of temporary service counted for the pensionary benefit, they were certainly entitled to be covered by the CCS pension rules. They would not be covered by the new pension scheme of 2004. And lots following this judgment, at page 54, the para 11, the issue whether such employees are covered under the CCS rules or under the new pension scheme is well settled, as the same issue has been raised not only before various benches of the CAT, but has been decided in Ajay Kumar. The judgment in Ajay Kumar Lords is extracted, and accordingly, at para 12, this Honorable Court found that the same principle would have to govern the present case. Therefore, the learned tribunal was legally justified in allowing the application filed by the respondent and in passing the directions mentioned herein above. Notes, I will not go into the details of the other orders. Kindly just note, notes, that at page 59 is another division bench of this Honorable Court, where Ajay Kumar is at page 63. His judgment at page 45 is referred to at page 63. That is the dictum in WP 11679 of 2011, disposed on 7/4/2015. 7/4/2015 is the order at page 45. That is followed, Malots, as being fully covered at page 65. And finally, Malots, at page 67, one other order of a division bench of this Honorable Court, Malots, following these orders and Ajay Kumar's case is at page 67. So, Malots, this line of judgments, I very respectfully present to service in support of my alternative submission that in any case, this scheme, even if it treats me as a new entrant, cannot apply retrospectively when a vested right to receive pension has already become available to me on the date of my appointment, whether your lordships take that date as 2003 or even as 2007.
Just one question.
Please.
Now, between April and July, isn't it?
April is when I was regularized.
Correct. And July was when the scheme came into force.
Please.
Between those 3 months, they did not have any contribution towards pension, etc.
No, Malots, because there was no contributory pension scheme in force. That is the grievance of the petitioners.
Now, under the old scheme that was existing,
There was no contributory requirement.
what was the entitlement for that scheme?
Yes, but we made a table for your options. We have extracted that at page 9. A comparison between the old scheme and the new scheme.
Page 9 of?
The synopsis. So grateful for your lordship's question. The difference between the old pension scheme and the new pension scheme. The old scheme allows in column 1. The retirement benefit is fixed. It was predetermined how much pension an employee will get
as it was linked to his last drawn salary and length of service. Illustration is if the last basic pay of the employee was 30,000, he would have drawn 15,000 as pension plus DA, and every 6 months the DA would increase. Now the new scheme makes a contribution of 10% mandatory upon the employee. So it is in that sense more onerous. Employee makes contribution of 10% of basic pay plus DA, and employer makes contribution of 14% of basic pay plus DA. Tier 1 pension account. Employee earns interest on his contribution. At the time of superannuation, employee is given pension on the basis of annuity value determined by the insurance company on the percentage of the corpus invested in the market. Employee has the option of withdrawing maximum 60% as a lump sum. So there are far more onerous and uncertain criteria here. In fact, such schemes have been vested before the Kerala High Court and other courts as being unfriendly to the rights of the employees. Because not only do they provide for a mandatory contribution and deduction, they are in turn invested in the market. Now, one way of looking at it is that if the market is favorable, the benefits, like in a mutual fund, could be skyrocket. But there is also a downside to that. There could be a loss. And therefore, my lords, when the old scheme provided some stability to these employees, did not have any such requirement of contribution, market investment, etc. That could be the scheme applicable. Some of the other distinctions, my lords, I have mentioned at serial numbers 2 to 5. But the crux of the issue is in serial number 1. That is this absence of contribution and in turn investment in the open market. Lords, I conclude. But page 116 of the case compilation. Sorry to take your notes back to that. This is, my lords, a judgment in Punjab Cooperative Agricultural Bank versus the Registrar's case 2022 Supreme Court, where this concept of the pension being a vested right is discussed. Please come to para 49, and I will close with this judgment.
Para
49, lords, at page 134. The exposition on 3-4.
yes.
Great, that's para 49. The exposition of the legal principles called out is that an amendment having retrospective operation, which has the effect of taking away the benefit already available to the employee under the existing rule, indeed would divest the employee from his vested or accrued rights. And that being so, it would be held to be violative of the rights guaranteed under 14 and 16 of the Constitution. In the instant case, the bank pension scheme was introduced from 1/4/89, and options were called from the employees, and those who had given their option became members of the pension scheme. And accordingly, pension was continuously paid to them without fail, and only in the year 2010, when the bank failed in discharging its obligation, the employees approached the High Court by filing petitions. The bank later withdrew the scheme of pension by deleting Rule 15(2) by an amendment dated so and so, which was introduced with effect, please mark this, with effect from 1/4/89, and the employees who availed the benefit of pension under the scheme, indeed, their rights stood vested and accrued to them, and any amendment to the contrary which has been made with retrospective operation to take away the right accrued to the retired employee under the existing rules certainly is not violative. Is not only violative of Article 14, but also of Article 21 of the Constitution. It may also be noticed that there is a distinction between the legitimate expectation and a vested bar accrued right in favor of the employees. The rule which classifies such employees for promotional seniority, age, or retirement purposes undoubtedly operates on those who entered service before framing of the rules, but operates in future. In a sense, it governs the future right of the seniority, promotion, etc., who are already in service. Then an illustration is given at 52 plots. For the sake of illustration, if a person, while entering into service, has a legitimate expectation that as per the then existing scheme of rules, they may be considered for promotion after certain years of qualifying service, or with the age of retirement which is being prescribed under the scheme of rules, but at a later stage, if there is any amendment made, either in the scheme of promotion or the age of superannuation, it may alter other conditions of service. Such scheme of rules operates in future. But at the same time, if the employee who had already been promoted or fixed in a particular pay scale, if that is being taken away by the imputed scheme of rules retrospectively, that certainly will take away the vested or accrued rights of the incumbent, which may not be permissible, may be violated, Articles 14 and 16, and accordingly notes.
Now, just one clarification.
Yes,
The terms of the new scheme,
lordships.
it comes into effect from
1/4/2006.
But if there are new entrants, how could they? What is the logic in dating it back?
They say all new entrants who enter from 1/4/2006. If I just show you of the language, page 40. APTCL is pleased to accord approval for implementing new defined contributory pension scheme with effect from 1/4/2006 for new entrants. It's a contradiction in a sense. Lords, if it was for new entrants, it would naturally have to be prospective. If it is retrospective, it is retrospective. Here, they further qualified as being effective 1/4/2006 for new entrants. What they seem to, my lords, want to say is that anybody appointed on or after 1/4/2006 will be governed by this. This can in no way, my lords, either apply to someone like me who was in service from 2003, because I'm not a new entrant, nor could it be made retrospectively applicable.
You have challenged the retrospective applicability also.
But the challenge in the writ is to the impugned endorsement, which interprets this GO to treat me as a new entrant. Because we are really concerned here with the applicability of the GO. The GO on its plain, the KPTCL order, on its plain reading is clear that it is applicable only to new entrants, which is why I said my alternative submission before your lordships is that it cannot apply retrospectively.
But you have to consider just
Please.
if you were to challenge the retrospective effect, assuming that the scheme applies,
Please.
then say that retrospectivity only will is for challenge. Then looking at it from that angle would be different from interpreting applicability and challenge to endorsement.
Please. Lords, in fact, in some of the judgments that I cited before your lordships, the challenge was not per se to the order itself. It was an interpretation made by me. And I will, lords, in my reply, point out those points. It is only a question of interpretation whether this could apply. My lords, the crux of the matter is that I was anyway, my lords, appointed on 30/4/2007. Your lordships have seen that. And that appointment was, I quite see, my lords, what is falling from your lordship, that if I simply speak to my friend, but I will show your lordships from
Because there would be a difference in saying that now if the scheme has come into force on 5th July.
Yes.
And you were appointed admittedly earlier to it.
Please.
That's one part of it. But if the scheme itself says it is with effect for all entrants, then what would be in challenge would be only the retrospectivity of the scheme.
Lords, my first submission to your lordships is I am not a new entrant. If your lordships
No, but correct, I'm just
testing the second submission, yes,
so their word new entrance is qualified from with effect from 1/4/2006.
please.
So there the word new entrant is to be read in conjunction with the 1/4/2006. And if that were to be so, in effect, they are saying that it would come into effect for all employees who have joined as on or after 1/4/2006,
Wait, so-
which in effect means they're giving retrospectivity
yes,
to the
yes,
scheme.
yes.
Examine that.
I will examine that, Lords. But please do, Lords, keep in mind the fact that basis the judgments of the Madras High Court, such persons can never be treated as new entrants.
Yes.
That is a pure question of interpreting the order. Please, I'm so grateful. Lords, that that, my lords, pension is a bounty, I think, is a principle too well settled. I can just point your lordships to the Supreme Court judgment on that aspect, which is not a bounty. I'm grateful to that. Page 138.
Which?
138 of the case compilation. But please see para 10. Even here, the question was whether retrospective amendment could take away the vested right. There was really no challenge per se to the condition. It was a case of interpreting the provision. Para 10. The High Court of Delhi had opined that once the benefit had been taken under the joint note of revision of salary, estoppel is created against the officers to claim the pension as per the existing formulae, which prevailed before its amendment. And amendment could have been made with retrospective effect. Thus, the Delhi High Court had dismissed the writ filed by the Officers Association, against which an appeal had been referred. The High Court of Madras and the High Court of Karnataka have taken the contrary view. They have observed that the joint note of 99 could not have supplanted the existing rules by regulations. Pension was required to be determined under the existing regulations. By amending the regulation and adding explanation C in regulation 2S in the month of January 2003, benefit that has accrued could not have been taken away. Thus, we have two contrary views of the High Courts to adjudicate upon the instant matters. So it was a pure case of interpretation. Now, kindly come to para 23. Pension is a right and not a bounty, and cannot be dealt with arbitrarily. In the instant cases, the existing provisions could not have been amended with retrospective effect, taking away accrued rights on the basis of the joint note, which had no statutory backing. The rights that have accrued cannot be taken away with retrospective effect, as laid down by this court in Railway Board versus so and so notes. I'll skip that. Those principles are too well settled. There are some judgments in this which may answer your lordship's query regarding the not directly but the related aspects of the status of temporary employees. Maybe I will come back to that. I'm conscious that I have two learned friends who have partners. That is my respectful submission in this rate. That not ultimately the rejection made by them is on a very flimsy premise. they conveniently treat me as a new entrant. Retrospective or otherwise really actually does not arise here because the cutoff date is of 2006 and my original appointment is 2003. That position is undisputed. And that being the case, the judgment in Punyam Koti Lords really covers the issue. Those were cases of casual laborers. The person working, be it albeit in a temporary capacity, regularized later, by no stretch of interpretation can be treated as a new entrant. Because I have not entered you in 2006, I have entered in 2003. And having entered and taken, my lords, the benefit of my services for that period, having created a vested right in my favor for pension by this one casual interpretation, the KPTCL, my lords, could not deny me that benefit. Therefore, my lords, that order is fine. That's my experience. We deeply obliged, my lords. Patient here.
Friday. Now, who else has to argue?
Second matter, on facts, they are identical, my lords. I'm referring to the second matter. There are 22 engineers, extended engineers, in terms of association.
So then, could we do one thing?
Please.
Now, now suppose we were to hear the other side,
Please.
then come back. Let's see what are the dimensions, what would come out from the other side, and then we'll come back. We'll come back to you.
I mean, put some propositions which may be. Please.
Then, okay. Then 23rd. 23rd. Yeah. So we'll have it on 23rd for further hearing. Huh? Morning, Friday, sometimes we'll have benches at 2:30.
Please.
Morning session.
Please.
Sometimes I take liberty with Aditya because he is my junior from law school.
Always remains.
So that must not be construed otherwise. Yes, yes.
Your Lordship, may I make a submission, Your Lordship?
Yes.
Your Lordship, serial number 67.1 in writ petition number 445. Your Lordship was pleased to permit the petitioner to implead the respondent number 4. That is 1.5 months back. That is on 3/8/2022. As on date,
Yes.
the process has not been issued and it's not been served. I've already filed wakalat on behalf of R4, as well as a filed for vacating application. It's a simple matter, Your Lordship. The respondent number 4 is always from the appointment till date, he's senior to the petitioner. Just because of the interim order, the petitioner is enjoying the post, which is in additional charge.
Your Lordship, there is some urgency in the matter. The matter may kindly be posted anytime on Monday or Tuesday, Your Lordship.
Let us see. I'll just look at the board.
Number 73. 73.
Yes.
There is extension of the sixth pay commission. During the pendency of the petition, the management has extended the sixth pay commission pay scales to those employees who were earlier filed the writ petition along with us, who withdrew the petitions. The respondent has to make a statement that I produced the proceeding. Vice principal informed the members about the implemented six pay scales to the non-teaching staff and extended thanks to the management. These are all the proceedings. Now those who are outside the court, who withdrew the petition, they got the benefit. Exactly, this is what my Lord Justice Krishnaya in Indrapal versus Railway Administration said. Approaching the court itself is an optional child. Those who are not approached, those who have approached, there cannot be a different standards. Now the management has to make clear whether the sixth pay commission has been implemented to those petitioners who have withdrawn the writ petition, who initially approached this summit. If the sixth pay is extended to them, then the petition has to be allowed only on sold.
These are 4 and 5. Is it?
Yes, ma'am. Mr. Murthy and Somshekhar. Only on this issue, my Lord, your Lordship could adjourn it to Monday or Tuesday. Only on this clarity.
This is the matter. Mhm. 28. 28. Yes.
May I make only a request, some observation. Annexure W minute I placed the proceeding. It says, Vice Principal informed the members about the implementation of sixth pay scales to the non-teaching staff and extended thanks to the management. This is on February 4, 2022. Only got to clarify this. Otherwise, the matter has to be. I have produced the application.
Appearing for the petitioner.
Annexure W, page 82.
Makes that. As for annexure.
W, page 82. Vice Principal, that is point number 3. This is minutes of the meeting dated 2nd February 2022. Third point, Vice Principal informed the members about
Annexure W.
Annexure W, page 82. Third point.
submitted the,
Point 3, vice principal informed the members.
he submitted the Legislative Council appearing for the petitioners that in terms of, as is evident from LPKW, minutes of the meeting of 2nd February 2022, the reference regarding implementation of 6th pay scales to the non-teaching staff.
Yes, my lord.
It is accordingly submitted if the respondent, employer were to make their stand clear as regards the same, the area of the controversy could be resolved. So the same.
Whether the benefit extended to those petitioners who withdrawn is extended to the present petitioner.
So this benefit is for all, isn't it?
Yes, 6th pay commission
correct.
to all, my lord.
So let them clarify whether this
Your lordship should indicate whether this decision would be made applicable to the petitioners or not.
It is upon being submitted that
I will
the
not press the
respondent
petition.
employers want to make the stand clear as regards this.
the applicability of extension of 6th pay scales to the petitioner as well. If that were to be so, it is submitted that the controversy could be resolved and there would be nothing left for adjudication. Yes.
Classification of employees based on the date of their retirement and not introduction of the scheme much later. For retired employees, no revision. In view of the fact that in 2017
The matter after 2 is the matter after 2 weeks. Immediately after Dasara vacation. Yes.
Okay.
Request made on behalf of the petitioner. Relist the matter after 2 weeks. Interim order earlier granted is extended till the next day.
All the branch employees of Basis City Corporation on par with those who got regularized. There were several employees who were working on daily wage basis. And similarly, before they attained superannuation, and while they were able to attain superannuation, they had locked the doors of this honorable. And in case of them, this honorable court directed to regularize their service. Thereafter, the state has implemented regularized their service and extended retirement benefit also. But these petitions, they were educating their claim right from the year 2001 by knocking the doors of this honorable court. In spite of several directions of this honorable court, Mysore City Corporation has not implemented. Thereafter, in 2006, your lordship is Umadevi. As one-time measure, it is the mandate of the Supreme Court judgment that the state should consider those who have worked continuously for 10 years, and if they fulfill all the conditions that is laid down in that judgment, we can fulfill all those conditions. In 2015, in fact, Mysore City Corporation forwarded the recommendation to the Deputy Commissioner, who is the appointing authority of the petitioners of conversion. But the Deputy Commissioner sits on it without taking any decision. Now, after that, in 2019, few of the employees knocked the doors of the honorable court. They came to know while the petition was pending that there was an endorsement issued by the Deputy Commissioner rejecting their claim. And similar endorsement which was issued was already set aside by this court as well as the division bench. Taking note of all these factors, the honorable court set aside the endorsement and directed to regularize. Subsequent date, they have been regularized. Now the petitioners have attained superannuation. All that they are seeking is consider them as deemed regularized so that they will get the retirement.
There is already an order.
There is no order. They are on pause. There is already an order in case of those who are serving and their cases has been regularized. And after filing of the writ petition, there is an order if they have retired after filing writ petition. They consider them as deemed regularized and extend the retirement. That has been implemented by accepting the order. Deputy Commissioner has passed the order of regularization.
That's a logical legal consequence, isn't it?
Yes.
Deal is the matter. Deal is the matter.
Lordships kindly, my lord. Is not able to come.
I'll adjourn it. I'll adjourn it to next week.
Very well,
Next week. Next week.
very well, my lord.
Let request release the matter next Thursday. Same stage. Yes.
Serial number 31, my lord.
Lord, serial number 32, my lord. I could not hear, my lord.
31, my lord. I appear for the petitioners in this case, my lord. Petitioners are all retired professors, my
No,
lord.
but, number 34. Correct, but that requires hearing is what they said when the matter was called. So I've adjourned it immediately after Dasara vacation. Next 2 weeks is a little difficult.
31, my lord.
Yes, immediately after Dasara.
Please.
My lord, serial number 32, my lord.
34.
Yes, 34. Matter after 2 weeks. Yes. Same order. Next.
7.
ಯಾವುದು? ಯಾವುದು? ಯಾವ್ದು entry ಮಾಡಿ ಹೋಗಿದೆ ಕಂಟಿನ್ಯೂ 37
Rajendra Kumar.
2 weeks.
8.
What basis the sanction was withdrawn? To take a stand on it.
On what basis?
Unless she didn't have it, the post which were promoted to the. The interim order has not been granted. So I felt I number 2. Without of the state order, they were supposed to. For the last order, my lord.
Withdrawal of the
Order dated 14/2016.
yes. The order sheet.
To read, my lords. Government to take its stand regarding withdrawal of the order dated 14/1/2006 by next date, release the matter.
The order dated
14/1/2016, which is the Anish area, my lord. It has been challenged in this litigation. Page number 32, my lord.
page petition to
Page number 33, my lord. Repeat. ವೆಂಕಟೇಶಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ತಮ್ಮ ಕಚೇರಿ ಉಲ್ಲೇಖ ಪತ್ರದ ಕಡೆಗೆ ಗಮನ ಸೆಳೆಯಲಾಗಿದೆ. ಪ್ರಸ್ತಾವನೆ ಪರಿಶೀಲಿಸಿದ ಸದರಿ ಹುದ್ದೆಗಳನ್ನು ಭರ್ತಿ ಮಾಡಿಕೊಳ್ಳಲು ಅನುಮತಿ ನೀಡಲಾಗಿರುವ ಪತ್ರದ ಸಂಖ್ಯೆ ಸೋಯಿಟ್ಸು ದಿನಾಂಕ 14/1/16 ಈ ತಕ್ಷಣದ ಜಾರಿಗೆ ಬರುವಂತೆ ಹಿಂಪಡೆಯಲಾಗಿದೆ. ಸದರಿ ಅಧಿಕಾರಿಗಳ ಸೇವೆಯನ್ನು ಹಿಂದಿರುಗಿಸುವ ಬಗ್ಗೆ ವಿಶ್ವವಿದ್ಯಾಲಯದ ಹಂತದಲ್ಲಿ ಮುಂದಿನ ಅಗತ್ಯ ಕ್ರಮಗಳಂತೆ ತಮ್ಮನ್ನು ನಿರ್ದೇಶಿಸಲಾಗಿದೆ.
What is the reason given?
No reasons are absolutely known. They create a post and they withdraw the post. As per the creation of the post, petition number 1 and 2 were promoted, my lords. Subsequently, this annexation, communication order 46/2021, they have withdrawn the given to the.
Take your stand. Now this has been observed in the order dated. Government to take their stand.
Last date, my lords, 24/8/2022. Last petition.
24/8/2022.
Petition. So far as petition number 1 is concerned, interim stay has been granted sound of the court. So far as petition number 2, I have filed IA for stay, my lords. That IA is pending consideration because my lords consideration.
Interim stay of annexure A, my lord, so far as petitioner.
But the observation when granting the interim prayer, it was only additional in charge.
Please. No, but the post were created because they were working as an executive engineer, assistant executive engineer. By creation of the post, my lords, in the respondent university, they were promoted to their post.
But the interim order observes that it was only additional charge.
Please, my lords.
It was not a regular post.
My lordship, may kindly see order dated 22/12/2021, my lords.
22.
22/12/2021, my lords. IA number 2, my lords, get it, my lords.
Yes.
IA number 2 is filed prior first day. Posting bearing number so and so. The court by order dated 25/9/21 granted interim order stay. The order dated 23/8/2021, so far as the first petition is concerned. It is submitted that unless order dated 4/6/2021 withdrawing the sanction put is stayed, the respondent Karnataka Veterinary University unemployment university would not be in a position to
You take your stand. You take your stand. On what basis you have withdrawn the post?
Absolutely no reasoning at all.
But on what basis the
Promoted from the post of assistant executive to executive. So far as petition 1 is concerned, it has been promoted in post. The posts were created. My lordship may kindly. It's annexure G, my lords. Annexure G, my lords.
But once you have created a post and given approval,
Promoted.
how you can abolish it? Government is given approval for a post, and the university has acted, created a post and placed somebody. That's a substantive order. How you can withdraw it? It's like abolition of a post. But 4/1/2015 itself, you have given permission.
But the promotion in terms of the creation of post. That is the chart also available in annexure. Actually,
Then you file something, whatever you want to file, you file. Relist the matter next Thursday. Next Thursday, let us next Thursday. The same stage. Government to positively take that stand in terms of the direction on 24/8/2022. 39. Mr. After Dasra vacation. Yes.
It's a transfer, mutual transfer. Office manager. You could see 4 days is there. Yes, he has been transferred. And in its place, exceedingly health inspector. We is not to look at the office manager. He posted annexure A is the include order winner. Page number 10. It is getting 22/6/2022.
When was your previous posting?
Previous posting is annexure B, my lord.
Annexure?
Annexure B.
On?
That is the 23/12/2019. Was posted as office manager in Nelamangala.
How many years?
But 3 years, my lord. It is for group C 4 years, sir. 4 years.
18 2.5 years has been transferred without giving any posting.
No posting.
No posting. No dependency. What is my lord? Minus the submission. Who has been posted to my place, sir, he is not belonging to the cadre.
No, whether who is the authority?
Authority is the government has passed the order, my lord.
Whether they have taken permission for premature transfer.
No, my lord, submission. No administrative reasons are also there. In fact, there cannot be because as per annexure D, this respond number 3 was posted to Kolar on 10 to 20.
That we'll see now. Unless you get permission for premature transfer, we'll state you produce a record. The petitioner submits that he was transferred to the present post on 23/12/2019 and transfer order has been effected on 20th of June 2022.
Yes, my lord.
It is submitted that petitioner belongs to Group C and is entitled for
Office manager.
security of tenure of 4 years. And the order passed is amounts to premature transfer. It's the AGA request for time. Noticing that it's an order of premature transfer, unless a procedure under the transfer guidelines are followed, the order of transfer would not stand the test of legal scrutiny. Accordingly, there would be an interim order of stay of the order of transfer at annexure till the next date. This is the matter week after next. Statement of objection to be filed by the other side. I've given interim order. What date you want?
Postgraduate qualified candidate. Yes, that
27th we have given a date. Let us see. 27th.
23rd.
27th. Let us see.
That is for past 3 months when it has hardly 3 months. She puts her time. Next week, any day next week,
Millard, with your lordship.
any day next week,
Only that day it may reach. We are not giving other matters on the Tuesdays.
Millard, lordships kindly, Millard, serial number 32, Millard, I appear for respond number 6.
Just wait. Huh?
This is CTV and cumulative grade points and average grade points, calculation of percentage. My other surveys are interpreted based on
Let us see. 57. Serial number?
next week, any date.
It will not reach except on 27. Let us see. 42. Give a short date.
Serial number 53 months. This relates to initiation of disciplinary inquiry after 4 years of the date of the incident. Last to look into the L. Chandra Kumar judgment and make submission. 53. 53 and 53.1.
Let us see.
Any date next.
Millard, serial number 32, Millard.
Yes.
Lords, then interim order.
Without making me as a party, my lord,
Last time
I
it was not
am a
extended.
candidate. However, my lord, the interim order has been obtained. My lord, I have filed an application, my lord, it is for hearing on IA. It may kindly be taken up next week, my lord, because the classes have already commenced. I am a professor in the political science department. There's the post is now at present vacant, my lord. I seek for a date to be fixed, my lord.
Won't reach even before vacation. If it has to be heard, then it's only.
My lord, I'm just seeking for a modification of the interim order, my lord.
Correct.
For
Now
this reason, the course is already started.
No, we have to hear it, isn't it? If
Yes,
it's
my lord.
not,
Yes, my lord. A date may kindly be fixed, my lord. It will not take more time, my lord.
it will be only in the first week after Dasra vacation. I'll give a date.
My lord, the classes have commenced, my lord. Now the students are suffering because of this interim order, my lord. The post is vacant. If it can be
If it requires hearing, then there's no point in taking a date prior to that. It will just be adjourned. I'm not in a position to take up any further matters.
This is the only difficulty, my lord, because now the
29th.
petition will also.
Let us see. You take a chance. 29th.
Yes, my lord. Much obliged, my lord.
Which matter is that you are mentioning?
32, my lord. 32. I'm for respondent number 6, who got impleaded.
After Dasra vacation, we don't have dates.
That's interim order. Last date it was not extended. First is not extended.
To bona fide lapse, interim order was not extended on the last date. Interim order earlier granted is extended to the next date.
Much more, my lord, is a retired professor of law. He has no pension, anything. He has to be given a UGC scale. He is retired. He can't even travel from Udupi to Bangalore. So lordship may give a date and have it after immediately after delivery, because from 2-3 months it is listed. My matter is not reaching. Your lordship may fix any date to be taken immediately after delivery.
Is the matter in preliminary hearing list in light of submission that matter requires out of turn hearing. Please. Each.
45, my lord.
Is the matter in the immediately after Dasara vacation, in the week commencing from 10th of October. Yes.
Your lordship, serial number 67, I was mentioning. Your lordship.
45.
Yes.
My lord, number 45, my lord.
Which matter?
After vacation, my lord. 45, my lord. That regularization I'm seeking, my lord. Yes, my lord.
But that's only a recommendation. Yes.
That may be listed for interim relief. Further.
The matter orders this. 28.